cheme kenyeme nyefenye yi ana walada nindanyeshi ake boli Easter Saturday ne nyeba fatawoye. I mean, a lot of people are having fun, and rightly so. Una bonini yo nila te no go is in the building. So ke obafitan ye engon na wadi enche ake obafitan he. Benyele neke court cases nele. It's gonna be a lot of reading. Una bonini yo. I am not a lawyer. I don't try to play one on TV. No. Ke ebale neke ma dian sanjin. Shout outs to you. Niamo shimpa kotopon. Mo klabe. Mo klabe. Niamo shimpa kotopon. Mo klabe. Ke ebale na kan tumoboni ole wasumoni wani mambie ale noni yano. Ni moko ekalaka moko. Agamale etwaga. Ni anukwale pe jiro ni baani ekumo. Amale chue ni ama. And that is why we try to do this, because Jemo Femo na deka ni court. Be pie wojine we ka ngla ni bi emi wati ame pie wonu shishi. So try to the best of my ability yake. E maka ne ye blufu emi keke ngbla mi ye gan mi. Latin jine kome no ni nu shishi ege inkebo. No ni nu shishi we I don't try. Ni ma kebo no go ni be mi. So na Latin logo again, alone na legal term ko again. Ni nu shishi. We will run over it. I will not force myself to try to explain. Ni magbla no go no le no. Inye Kenya law school minen jemfi minen jengenya so ntenkwe ebawa chinya so no ni wonu shishi ke efa ke sani wo ge lawyer fo nyu ababie ni ebagbla mi benye lomo we lawyer fo ni wo ba wo reach out to amen. Ni ameba wawa. So like I said, it's gonna be a lot of reading. Mene ofine hamigonti no ni ya ko jani fe mo ki amoko ni lenwe ki amoko boni afe no no ba yu e gan mi ni moko akaya eko ni amale. Class captain ayu oda body there yo ni mogo agafe ekole dote baya no ni say ni get mami you get worry. If there is one thing ni mami me inform me, it's because I didn't go to law school like she wanted me to. In say get worry ekole dote baya hale. Dote will probably go into law. So he's a great debater. He's into political science. Dote is pretty much doing the same things that I did. He's a great writer as well. So it's like, yeah, car for low from lele bona. The only thing ya get me and now one UOP, dot UAP. No one you know more famous, she like commit to LA. He's always quiet in his own ball corner. But academically, steps didn't take here. Leun Nakano is in the same thing. It's in the debate club. It's in the drama. Like he's doing the arts. It's everything. Smart, if political science, a little bit of economics. He's doing it all. So, you know, get my worry. Dote ba law school. That is if he wants to. But anyway, so it's gonna be a lot of reading. We're gonna try and do a lot of reading today. Once again, to my morning Kobwe, it is not because we're in Chairman Cheko. As a matter of fact, recently, I hated the familiarity, and I still hate it because when you get familiarity, and of course, as I have grown in this space, familiarity, me personally, I don't like it. Because kefe na ke ani nu chumo fia unto bona because ke onyo yue mokosane ni bu ke sho no yue then this ani moko club abu obotwe ni try you cannot be trusted. You understand what I'm saying? So ni what the more ni what channel ya no ni da, the more ni familiarity da, and I hate it. Trust me. Inta ho na kan no go but I cannot help it because nyeko ke cheko ni for me. So no nye mafe nuko bona boni ni yo. But we'll try our very best to be as objective as we can to give you the truth and nothing else. You've put in your trust in us, and we'll continue to hold that trust highly, highly, highly. We don't want to let go of the trust, because it is one thing nigga will break it, and we always have that at the back of our minds. Okay, and we should not let you down. And we're going to try our very best, me and my team, to make sure I keep to that kind. That oath, ni was swear, we will always present the truth to you, regardless of money, ni ayu, we'll continue to do it. You understand what I'm saying? Trust me on that. My team will not even allow me. Keji Ibale, and shout outs to my team, shout outs to Ayabache and the rest. I mean, Aileche, Okaleche, Akuche, everybody keeps me on my toes. Charlie, famous steady. And I appreciate the team that supports me all the time. My Roberta is right there. My Roberta, class captain again. Ever fail class captain, your chat session. Class captain, class captain. My Roberta and class captain. So mean that your friends. Shara Drake, welcome, assistant class captain. Anyway, so let's go into business. Before Nii waba bote mene noni waba chuemi. Let me show you this. Ofine keji oye. Okay. Ke oye Minnesota niami. Benye bakayage menejik biete nke well, that is my cousin actually. For some reason cousins near BF. I'm a charming uncle. So be Kenya last ebona. So be Juni Bane no ni late no kueje. Wafe wa ni late no kueje. Benyele ni jenyo. Easter love feast, excuse me, for children. So ona Mr. and Mrs. ona me jeme Monday, April 6th, 2026, 3 p.m. Treasure Hill Lodge. Noko Jane, Latte Man. Bona. So join us for an afternoon of games, food, and celebration as we share the love of Jesus with the little ones. Sponsors are Treasure Hill Lodge and Shalom. I mean, it's a bunch of them up and down there. So, find it. Yeah, you should buy me. Nyebo amodi ene eyano Ghana. So, bomodi Easter Love Feast for Children. Ona ni late no gweje niji enyo ke Mrs. Abigail Ayiti ni late no gweje fatalo. And of course Jeremiah Ayiti. So Jeremiah lejo no gba lo leji bibio last time benyele nkene ma no chombo Greg. So leun le yo bi ke Felicia Fraser. So bomode Monday nani ba Treasure Hill Lodge ye no gweje late man. Kegbeke bi ya yefita me ni gbeke bi ya celebrator be juni ba ne no bona Easter Monday Easter jambi na agbe ni bomode ekole Yesu baba so kena agbe ni bomode ni oya ni oya enjoy na ni Yesu baba. Okay, so Uncle K is the older one. Okay, so Greg nyemyo nupa, right? Ni leno money sponsor neke no go free money. That's right. So ofade nyebo amodi ni nya kwa ameyi say fine wa denche bona bonne. Shout outs to Jeremiah. Hopefully one of these days maba Minnesota ni mama na nyefe Brakote eba fatawoy. Shout outs to you Brakote impa ofine be oye ojogban. So Biaminimingbele inieni makane mahanye. It is only 24 pages long. So it's a jake only 24 pages. Actually bam noni over 60 pages but what can it be? So kayotri matwale bam keke ona. Now biamini in document 10 billion. Manage no ni ke contempt case in ba. What actually brought this contempt case? Now, shout outs to you, Mr. Jean, Ofane be Oyojugba. Felix Ayikwe, Ofane Bebo Oye Ojugba. Inyemi, mi yake Oye Ojugba. Miniji noni keneke contempt case in ba. Akuko photo, shipon e pelemo ye, sani e age court. Ni e age court, kaji ofoloko, wo. Allow miss one or two things, min recap konyo na. Ni sani aye kote e aje kote aye eshi Nii Adote Otinto ke Sempe bi ni aye eshi ame. It was around last year omowo biami ni Nii Adote Otinto yue moko biami ni e file noni wachole stay of execution pending appeal, because Nii Adote Otinto nakan judgment appeal to the higher court ni akwemi ake boni lower court rule le ege pangbi so mo go back akebe esani shukun ne appeal pe ke shi nakan she ba yue mo ne ama twa yue mo ni e ba yue ehabo ni neke yue mo ne ba yue ni ehani Nii Danso niji Danso Mantse ni eke be Sempe Mantse apele neke is it dabi imbepo well nakan Danso ma enclave ya akuko photo jamele was between that week ni ne ba nakan jamegbe enclave bona nye kayo wabana kayo chi wabana eno na you one ni wabana kenkan e ba chonwo so Nii Adote Otinto ate blonya omo work na gbe na ni e ba yue mo ne ni eje yue mo ne no ni wache Nii Danso ni Danso Mantse a file contempt against Nii Adote Otinto kenya ba kaye nakan woloe ni a file e court in ba fe show ye kaji o taw ni na no ni poten ni Nii Danso kete court ni mene a rule ke oten channel no video say me Nii Danso files contempt case against Nii Adote Otinto. Obana ebaje boyi kono tashi nkane no fe no ni yo na kan file na mi no ni Nii Danso ke no ni eta woni court afe nkane fe mentries in nkane fe ni mene ruling eba ni mimba ma kande mahabo ne nya wobo ano ni Nii Adote Otinto yue twe ni ekeneke contempt file mo ne ba o fine ami gonti no ni ya nwe jani fe mo ye ishiba mi kiamoko ni lewu eke amoko.
Wa yo mo wo so no kan no wo gbina dana ameyo na ka mo dra mi yue ne nation so bi ade aka so na me yo no se person wo yo mo wo ameye omo wo e wo ka de mbe na se ke ya ameka church ball na me swani don
So this was after the court a rule against Nii Adote Otinto. Court a rule against it. Then I can shipon jinye ni anwo ni aka choje me ni ashwani don. Right. So chemeka nyeme be nyena neke video ne ni of course yuemo shorte kome fita neke yuemo ne ama ya se fio ni obutui.
Ka wa yo mo wo so no kan no wo gbina dana ameyo na ka mo dra mi yue ne nation Nii Danso bi ade aka so na me yo no se person wo yo mo wo ameye omo wo wo ka de mbe na se ke ya ameka church ball na me swani don
Right. So there you have it. Once again, it was a threat to Nii Danso K1B. And of course, I was looking at video fan ni matramabo na this is not in finding. But you guys remember nye meni nyeka we be a chair nyena now. Okay, wa previous video ni infe no, but the full video. The full video. As a matter of fact, yeah, I was so tired. So I tried to, put one or two things together for today's show. I didn't do any prep. I'm gonna be honest with you. I was super tired. I went straight to bed. I didn't even sit for a little bit. I just went straight to bed. So it told me why I didn't check. But like I said, if you want to see the full video, the other one then in me. So no Nii Danso domono because get caught a ruling against Tibo ni oyueneke yuemo be oche court here mini atwa. So Nii Danso ya file contempt against Nii Adote Otinto mo benin ko boy na kan file name back tabi en kan document e fen habo. Last week court ruling no manage court ke nyani wo boti amli boni afe ni wo kande ni wonu no ni court ke. Right, so in screen no friend of your jogba class captain over nebe ona document ni in project over nebe ona you find a benye friend na document ni in project benye friend na koni ma proceed kaya the other screen mtama face like any friend na ona mini ona document can you see me and can you see the document behind me as well? You find a animalia konima channel. Okay, got you. Thank you. All right, so let's go on. In the Superior Court of Judicature in the High Court of Justice held on the 4th day of March 2026 before His Lordship Kenneth Edem Kujoji, Justice. Let's go on. So na meji meni ameke sanie teye. Is it this one? Is this what I want? No. Mimba. Dabi jene sani nke chombo ene nkeba chombo. That's also kayochi. This is also part of if time permits at makande mahabo. Makani no mabo kayochi minta makani contempt no first dani where stay of execution there no ninke chombo first there ani magbele contempt no yes this is contempt no ne great contempt no nyani nke chwanye yeah, the whistle eba trashi. Yeah, so contempt no ne no jino ni imin project your screen there no. I hope ake no fe no ye nyena le ojugba. So nya wa boti ami ni wo kan once again no jino no na in the Superior Court of Judicature in the High Court of Justice held in Accra at Land Court 4 on the 25th day of March 2026 before His Lordship Justice Kenneth Edem Kujoji, Justice of the High Court. So it is between distract me. The Republic versus Nii Adote Otinto II, respondent, and of course ex-party Nii Danso II, applicant. Benjali, anytime it's a criminal case, it is the Republic and versus you. You understand? Every criminal case, when you commit a crime, you commit it against the Republic. So nakanjiboni yo. Any criminal case, the Republic versus, and of course, money fali nakan application leji danso mamanche. Nii Danso niji enyo. So nyawa boti ami. Ni wakwa noni kote ke. Ruling. The jurisdiction of this court has been invoked under Order 50 of Constitutional Instrument 47 for committal for contempt filed on 9th February 2026. The respondent filed his affidavit in opposition on March 3rd, 2026. One may ask what precipitated the application. One may ask what precipitated the application. Where the no get ashin again. Precipitated this application. Okay, nimin chele negona, nimin chele America, mi enchelo duba, nimin chele Ghana, mi ya. On 15th of April 2025, this court delivered a judgment in favor of the applicant in a land suit in respect of about 14 acres of land situated in Danso, a suburb of Accra, against Sempe Mantse and 2 others. So court tenke wake mini kana kesa ne neighbor. 15th April of 2025, the last year. Court no a ruling in favor of Nii Danso ye shiponko ni apelehe ye Danso man niami. Ne kesa ne ye between Nii Danso chata and yoni abashi. Ye between Nii Danso ke Sempe Mantse ke cheme enyo kome ating a rule against the Sempe Mantse ke cheme enyo nifite here in favor of Nii Danso shikpo enye apelio hine 14 acres jishikpo ni apelio here. Now, following the judgment and service of the entry of judgment after trial through substituted service, the respondent organized a pre-or walk in memory of the late Sempe Chief of Staff, and on the said occasion delivered a speech which, in the estimation of the applicant, sought to disregard and defy the orders of the judgment. So, ni judgment ne nkwe se eba class captain kango kogmo inye bado ngolo ye ido. Last time mo keke fie iwe blofo eto mo ko ni eje mo ko ni eje gan ne ata blochi she kefie me force ngele no force ni ma chon ya America yo I don't so kefie me try ke ma sound more Ghanaian ke go na ke ani me teleshimo I cannot help it. I'm in force eka. You understand what I'm saying? But so content chono gwage ni ayeneke sa ne name but what Nii Adote Otinto organize pre-omo walk ni organize pre-omo walk naga no mi ewie mo ni ya wacha Nii Danso susumo mi mo na ewie be etawni eche court anyi atoa judgment here ni a rule against like Sempe bi mo ni wacha Nii Adote Otinto ye wacha Nii Danso susumo mi be etawni no ni court ewie eteke court wa ke ebu no na ewie ni echi court here atoa. Now watch out. He also threatens the respondent on account of the decision which went in favor of the latter. No say when a threaten what Nii Danso ke Danso will be. You clearly heard what Nii Adote Otinto kake keji Nii Danso me ashwani ya me eba crash ya me ameka choje me klake wo. So that was a threat. So jeje nchono gwake neke no we woni akeba. Penal notice was served on the respondent to retract and apologize for his action, but he failed to do so. Neke penal notice ne ke obaka ye no umba tabie ni mbaka ne habo. No se ni wacha Nii Adote Otinto yue neke yue mone. Once again, wacha Nii Danso ke lawyer foe ame file kete kote ni ame ke kote ake ni wacha Nii Otinto ake yue mone ba yue one e threaten ame. Taoni etwa ke be no ni kote yue ekachuni no eba man ni eba maintain etomobone edumoshine yue no ni egbla na kan yue mo se. Of course Nii Otinto be na alake na kan yue mo ne ba yue egbla se be ho ni egbla se no be balake isani wacha Nii Danso eke na kan sani aya court ne file for contempt no jino ni onani e file name. Now arguments of applicants mini wa wacha Nii Danso nkake noni wacha Nii Adote Otinto fe ni afa penal notice halake eba glass ne glass mino wache Nii Danso mini no edumo ni ekete kotu ne kake akwanono ni a charge wache Nii Adote Otinto ke contempt none wabuatwe again from the tenor of his arguments. Applicant contended that the respondent had notice of the judgment, which was served through the national dailies and on the walls of the Sempe Palace, which the official residence of the Sempe Mantse, a position currently held by the respondent. Wache Nii Danso nchono kwake. No animi nke ake afaili wache Nii Adote Otinto eyemo ke ni bi na efe eche court yin atoa. Ni judgment here ba was serve leko eni ne channel. I use substituted service. Ni ate ni ake pete hey eni amamo mamoy Nii Adote Otinto ekeshikon ehame ni amamo mamoy ni bi komeye no fe alo amamo mamoy ni bi komeye no ake judgment je apete je me fe ni mo fe mo ana ake shikon court we rule ake je Sempe mano agbene le Nii Adote Otinto a palace ni etwo ni nkejo mi ake Sempe Mantse ake ni ekon ya pete je me ball I apply for substituted service keji otawni okanoko amuku ni ona mo mondojibo alo mo lele ona le o try o tawla anu no na ba ya court we ni o ba aka ke na ashimashine ntawla anu na le ni nke ni e ba le court e ba gbegbo ake okay call e shian ke ye shian call e office ke ye office ka pete je me ke be ba na no so na kanjino ni afe ni o ba na aka pete efe aka pete nke na kan video se hu ba chombo. According to the applicants, the speech of the respondent, delivered after an organized walk to celebrate the memory of the late chief of staff of Sempe, disobeyed the judgment delivered by the court and denigrated the fourth plaintiff. Nichwake, yue moni wache Nii Adote Otinto yue, biamini anye ata, ye wache Nii Danso susumomiye, nakaino, be, wache Nii Sempe ebu kotue. Etani kotu anake ebu kotu ni nakan no nwe nakan yemo no ewo wache Nii Danso emuji. Shout out to you ma Emma o fine be oyo ojugban so ni bi enyo second one jino ni eyue ne ekomeji ni afe judgment ata ekawojin pete efe ni ana Nii Sempe alo ile ake Nii Sempe yo je kan nakan chujia efe ake na judgment one against ibone no ni ji enyo nwe yue money Nii Sempe yue yana kan walk ehihie clearly etwage be Nii Sempe ebu court ni le wache Nii Danso ele nwe Nii Sempe ewe muji. Applicant argued further that the speech sought to incite violence against the fourth plaintiff, considering the fact that the maker of the speech is a Sempe Mantse and are subjects who are willing to heed his message. So chono wake yele susumomie Nii Danso susumomie yue mo ni Nii Sempe yue nakeno Nii Sempe ntawni eke basa aba ejage Nii Sempe Mantse ni ne ye me ni yo ehihie ni nakan me no fio no na ba aka me ame ba chu nakan nu chumo pepepe no wo Nii Danso Nii Sempe ntawni eke basa femo aba. In his affidavit in support, the appellant highlighted some portions of the speech as follows. Application any watch Nii Danso file here. Yemo ekome ni watch Nii Sempe yue ye na kan walk mi eke kome fitai. Koni jeje ana alo court anake jeni le Nii Danso eba fonsandi. She noni poten ni Nii Sempe yue ni. The land where Nii Danso's father's property is situated belongs to the Sempe stool. Noko eko nibi ekome ni Nii Sempe yue jake. Even la wache Nii Danso Nii Danso manche any taflache eche shia ma dienche na kan shikon Sempe mano. Nii Danso cannot claim parity with the Sempe stool. Le Nii Danso enye kake eke Sempe sen ye igbo. He has no land to his name. Ebeshikon kokla ye gbemi, rendering him a ceremonial chief without any land. Ni ake ebeshikon kokla ni pete egbe ye. No chuage le Nii Danso manche ne yole esa na bu because manche ni beshikon no ni Nii Adote Otinto yone. To the applicant, the above statement represents public repudiation of the court's finding and tends to undermine respect for the court. Nii Danso susumomie neke yue mone eche court to e atwa boni court to e kwesane mi ni ebuasane neke yue mo na ni sempe yue be ni sempe ntane kake no ni court to e find here e no pagbi ni be ebu court to it. Now B, I did not forcibly take any lands from individuals. Rather, I will define and collect lands rightfully belonging to the Sempes too. No kwe ni sempe yue jake le eke by force eke gidi shipon yemadi shimon le ehani mokwa kot sempe noko no fe no ni e belongo to sempe eba no ni eba he sempe ni eha sempe. Now neke yue mo na enwe Miniji no ni wacha Nii Danso keye. Again, in the applicant's view, the above statement is in defense of the order of perpetual injunction restraining defendants. Wacha Nii Danso kake neke yue mo ne ni chwage be neke bechini ni akeme ni sempe no ake aye sanie abwa mo ne ni sempe ele e file appeal what Nii Danso introduce no kun ye bie e ka ke okay ake perpetual injunction ango no kaya shipon no don court to a rule like me no na kan judgment ke okaye from the high court okaye court you na kan I injunct what Nii Adote Otinto ake e kaya shipon no don a rule e Nii Danso so Nii Danso sumo mi ne ke yue mo na ni what Nii Otinto you be ne ke bechini ni court to e kan me ni sempe no be what Nii sempe ntawe kake na kan bechini ebu na kan injunction ebu. They are agents from interfering with the land. The statement constituted a refusal to accept the decision. Once again, na kan no ebu bechini any court to ekeba ni agbene hu ebe etani wo fe wana wa ni Otinto ntani me aye yake na no ni court to ewie eketuni. Shout out to you Kushmelo. Paragraphs D, E, and G are all portions of the speech which declare the intention of the respondent to cover all Sempe land. The said statement was regarded by the applicant as likely to provoke breach of the judgment and runs contrary to the subsequent declaration of title awarded to the applicant by the judgment. Naka ni chwange ako to paragraph D the active and again me fe keji okwemi obana ke belele wache ni sempe nte ke court to ake no ni court to ewie le ekechu ni no ne ewie ne keji no e ba fe ni chwange be e fe no conclu ni court to emelegbe ake efe. In paragraph F, the respondent's speech, which was considered by the applicant as a direct threat or of violence to the applicant and persons who may exercise rights under the judgment, is reproduced as follows. Your paragraph F of the filing ni what Nii Danso fe court to enchwake yuemo ekoni Nii Otinto yue ni ya Nii Danso susumo mie na kan yuemo eke basa fe mo baba alo e bani afe many ayesanene in their favor emana fia me basa no jino ni makande eke I will take the necessary action to protect the interest of the Sempesto. If I ever set eyes on them doing so, I will crush them. If they wish to eat pokoi, they should do so in the privacy of their own land. So what I need Sempe ke ba kaye eyuake e ba fe no no ni ntwabu ejameji no onu that portion energy no ni your video emi e ba fe no ni Sempe no e ba ko ni ke ename ejame e ba crash ya me keji ame town ni ame yekpeku benuele ame yekpeku ya me de nche amehia. The applicant contended that the said statements have caused great apprehension and tension within the community. What I need so chwa ke nege yue mo ne any tension eba mami any ekpokpomofio eba a community as the subjects and grantees of the fourth plaintiff now live in fear of attack or eviction by agents of the Sempesto. So many may all no ko shegbe especially kamoko any ball ekole shipon no yo me Nii Danso ke hale shegbe finally the applicant concluded that the conduct of the respondent is a deliberate attempt to bring the authority of the court into disrepute and to incite disobedience to its judgment. So tumobeni wakani efe what Nii Danso ke ya neke yue mo na mi ke ni bi efe ni Nii Adote Otinto fe eton ake be etani eke court to ehie atumo shpon ne ke court to ake no ne wie ebu. Now, miniji Nii Adote Otinto na GMO. The respondent vehemently opposed the application, and the bulwark of his argument centered on the requirements for successful contempt action as stated in Republic versus Sito II ex parte for July 2001 to 2002. Supreme Court Ghana Law Review 322 at 377. So, what Nii Adote Otinto ke dabi noni what Nii Danso ke ba ke yemone UFN no me fe nke kokla kpagbi court to noni ewe noni le what Nii Danso you jena kan so ona ekoti case ko yebie Niji Republic versus Sito II ex parte for Juo akekaji akwe nekesane na ni Supreme Court year between 2001 to 2002 abayo se ake noni Nii Danso you esani aketwoni. Counsel for Respondent contended that there was no ambiguous order in the judgment which has been flouted by the respondent, especially so when the boundaries of the land subject matter of dispute was not delineated in accordance with Section 179 of Land Act 2020. Nii Adote lawyer fo ekake no kokla bemi ni chonake noni Nii Adote Otinto yue be eche court to en atwa ejake shikpo na apeli oye agbala na kan shikpo in accordance with Section 179 of Land Act 2020. I believe this is one of the things I rely on. Keji Supreme Court Taneken case in no that case, this case is going to the Supreme Court. So Kayotri nowhere you already know. So Nii Adote Otinto lawyer mi dabi keji akwen again Land Act of 2020 Section 179 shikpo agbala kole ojogban no yele amesusumo mi Nii Adote Otinto efeko efom. Consequently, non-compliance with the above-named provision of the Land Act 2020 renders the judgment unclear and unambiguous. Once again, because of the Land Act, because judgment any judgment feel unclear. You understand what I'm saying? Once again, this is clearly one of the arguments that they will be using at the Supreme Court. Give you away. I'm sure Nii Danso lawyer say will take notice of this and I'm about counter accordingly. As regards to the second leg of his argument, counsel for respondent argued that the respondent was not a party to the proceedings and therefore had no personal knowledge of the judgment. So lawyer fuele ona. So enyo name shout out to you Mamele, shout out to you Manvik over nebe nyefenye yojugba. So enyo ne no court Nii Adote Otinto court lawyer and you excuse me nyege kiabe lawyer fu ona ake neke sanene na ye ne Nii Adote Otinto bemi no keji judgment ko eba na ken judgment here ele eko no ne konwe court ne. He relied on paragraph 470 of Hasbury's Law of England, 4th edition, volume 9:1, to buttress his point. Clearly, lelem saniani aye Nii Adote Otinto bemi. Bona boni ni yo Nii Adote Otinto bemi. Lele saniani ayo That's right. I take it on. Je basa maema eni take it on. Lega wolo ba biti le bolo. Wolo ba biti bu. Shout out to Nii Adote Otinto. Impa boy ojuba. Inwonu jibu. Bola aga nwonu jibu. Ngebu fine. Numo ngebu fine. My boy ojuba. That's right. Remember trying to audio abo. Nii Danso egele efe gidigidi. Egele efe imbatwayabo. If you guys remember, egele efe gidigidi. Egele wolo ba bitibu. Egewolo keicho ba bitibu. That's what he said, and he clearly is doing it. A whipping Nii Otinto left, right, and center. He's just whipping the. Mawa kenkago. Mawa molo ya indo ona. Nii Adote Otinto nwonuni ngele fine. So, Leleng, Nii Adote Otinto, nege lawsuit ne bemi. It was the then Sempe Mantse choice ke Sempe onukpaye eko ni wache Nii Danso ke nyeme kamete kote. So be an anukwale ke Nii Adote Otinto ke neke sanene bemi eko anukwale except you cannot say you had no knowledge of the judgment because I execute judgment ake ko pete Sempe pali say ake ko pete fe and of course ke obe knowledge of the judgment me no oba no responder me no na judgment no oba no way. If you have no knowledge of it, why come out and make such statements? You understand? Bona ona boni ni if you have no knowledge me no oba no you clearly ole no ni ya no no oba you but once again the lawyers are taking note of it. Niame provide case ne Kwame Tete at page 612 Republic versus Kwame Ajimanbedu ex parte County Hospital were also cited in support. So there you have it. According to the respondent, the statements made, which was repeated in paragraph 15 of the affidavit in support, do not amount to contempt, as the said statements did not bring the authority of the court in disrepute. Nii Adote Otinto lawyer Ancholo Gwake neke yue moine ni wache Nii Danso ke ayue shinwe be ake court we yin tumo shikon naka no dabi ameke pangbe ejake naka no e court to a judgment here yiku. In conclusion of his arguments, respondent was of the view that there was no willful disobedience of the court's order. Ya mesusu momie no ni Nii Danso UF ameke pangbe ake be Nii Adote Otinto eche court to yin atuma. The case of Ajenim Boatin versus 27 orders versus SK Boatin 2009, Supreme Court Ghana Law Review 154 was also cited in support of the respondent's case. So now holding snefeni amekefitai ni echon edomo ameyuemo se analysis. Now, nya wakwa no ni jeje ebo netwe miniji no ni ebua ye nyon femi. Alo te eke nyon fen banagbe te mnule shishite. Let's go. I have to state that from the tenor of arguments canvassed before the court, I get the impression that the parties do not fully grasp what contempt is, or simply put, they do not know into what category to place the particular contempt being alleged to have been committed by the respondent. So, clearly, me yenyo feni ake contempt sani neba amele any poten ne sani ameke neken contempt sani ne awo. Now, in the case of the applicant, he argued the application with reference to different types of contempt in the hope that the respondent cannot extricate himself from any. Yeah, keje kwa wacha Nii Danso eyuemo ne yuo nyema fe no koye wacha Nii Danso wacha Nii Danso esani ene keba elo eyue ni bi ni bofe boni wacha Nii Adote Otinto ba afi bele enye ejie yemi. On the other hand, the respondent chose to rely on a particular type of contempt and tailored his argument to suit that type of contempt. Nikeji oshe Nii Adote Otinto no nwe. Mind you, ke wacha Nii Danso with the hope if any Nii Adote Otinto ba chon at least eko ba mole nike wache Nii Adote Otinto jele nwe leo ejegbe ekomeko ni twage bia ne content chon woni echona ga different types of contempt wache Nii Adote Otinto le we ko ekomeko ninu ekba pon na kan particular type of contempt ni eka defend boni ofe ni bi ni wache Nii Danso yue eko akamole. It is in this regard that I will begin my analysis of the application by elaborating what conduct constitutes contempt, and in so doing, unravel the category of contempt arising from the application. So, no masumake majeshishi ni magba contempt mi ojogba boni afe ni wafe woyose alo wana the type of contempt no ni poten ni akeba. Because many can so contempt here eda many lo ni big many do milenche batacha get judge nkwani bi efeni mabotemi koni wana any potent contempt no ni potent niji ninu ewo esani ake neke sani na ba so jeje ba chon woni nya wo fen wo kase ani Oswald, in his iconic book, Contempt of Court, 2nd edition, page 6, called from in R.E. Efijuase's Stool Affairs, The Republic versus Numapu Ex parte, Amayao, the second and others, 1998 to 99 Supreme Court Ghana Law Review said, speaking generally, contempt of court may be said to be constituted by any court that tends to bring the authority and administration of the law into disrespect or disregard or interfere with or prejudice parties, litigants, or their witnesses during litigation. Agbene bluffo 5 year. Tema gbla mi ten. So yeah nchono kwa ke neke court nene leke sanene ne court we. Ke ake wa fe contempt bla oni wa yue koni moko ni your class 2 ba no hihie. Ka ke moko fe contempt be moko ne fe no ko ni eche court we ni atoa. Court we yue no ko na esumo ne ke twon ni alo sane kon ya no e court ni eyue no ko ni nakan no e ba futu sane be eke ngwo sane ni ya no e court we ni sa ni eke womi alo moko eyue no ko ni sane kan court we no efetumo kojo sane kan court wa ye ko atanko ni le kojo. You understand what I'm saying? Kojo na kan sane no ne keni bi na efe generally e ka ko define contempt ne keni bi na chon contempt. The phrase contemptuous query has long been recognized in English law since ancient times and has in the mind of some judges and legal writers been deficient in the description of the legal principle. Lord President Clyde, in the case of Johnson versus Grant, 1974 AC 273 at 315 said, the phrase contempt of court does not in the least describe the class of offense with which we are concerned. The offense consists in interfering with the administration of law, in impeding and perverting the course of justice. It is not the dignity of the court which is offended. A petty and misleading view of the issues involved it is the fundamental supremacy of the law which is challenged. So once again, no need judge in we court the get holding in court here be in chono gwake. Pretty much I can't get contempt but you are interfering with the administration of law. Bona court where you no go ni ko en womi ni sa ni ko e womi ni koni na kano impede ona allow prevent the course of justice. So na kano ko en womi koni echi sane yeli boni sane ayelo jogba echi nakan no be ona boni ni yo. So nakanjino shout outs to you Atago, shout outs to you ma Auntie Maggie Osuyo Papa, shout outs to you Auntie Grace eba trashi kwawo mlenche Auntie Komi ishwen ikula le eba trashi mawa over the Auntie Grace le boli correct one say godi nye mawa ke need to take aunties mawa over the Auntie Grace le correct one. This law and its forms were explained coherently by Lord Liblock in Attorney General versus Times Newspaper Limited 1973 3 all ER 54 at 71 as follows. The provision of such a system for the administration of justice by courts of law and the maintenance of public confidence in it are essential if citizens live in peaceful association with one another. Contempt of court is a generic term descriptive of conduct in relation to particular proceedings in a court of law which tends to undermine the system or inhibit citizens from availing themselves for it for the settlement of their dispute. Contempt of court may take many forms. So anyway, pretty much a generic form me o describe beni chwake e jino go ni go fe be ekagbechi noni ko 10,000 efie chimambi agbe ni anye afe na ken keji ataw ni aye saniko no egbla mi ake ka contempt of court ya many forms de komeni ejeje ba chon. So contempt consists of two types, namely civil and criminal contempt. So aye civil contempt ni aye criminal contempt. Contempt, simply put, is a conduct which constitutes a disobedience to the order or judgment of the court, or conduct which constitutes an interference with the due administration of justice. So blofwe pi ni wakande babao ne jeje efele bi egbla mi a wotomo class 2 begebi ni wanu shishi. Ekeka ke contempt bebo moko disobey order from the court. Bona alo efe noko ni nakaino eke ngwo sane komi ni kan court to ne sa ni eke wo nakan sane mi eja ke nakaino ke efe e ba ni sane yele ni your court to eka ya le ojugban. So jeje egbla eyawo. In early claim Agbemava versus Alfred Tua Yeboah Asante Bedu versus Attorney General Consolidated 2017 to 2018 Second Supreme Court Ghana Law Supreme Court Legal Review 923. The court said it is well settled law that there are two types of contempt, namely civil contempt, which consists of disobedience to a court order by a party to a case, and criminal contempt, which relates to the interference with the administration of justice. So, so I have two types of contempt. I have criminal contempt, civil contempt. Civil contempt, court to a ake femo neke alo ka fe neke court to e an order ko court to e ka shiwo ko eba ni oye no civil contempt ni criminal contempt eji ni o fe no ko ni o ta o ke gbasane ni ya no na ye court to. You understand what I'm saying? You are interfering with the proceedings, with the processes ni e ya no e court na kai no le. It is criminal. So je blame ye nyawa. I a civil one je ke bo party A kaya party B, that is an order. Ni je keke oti no, it is civil. Agbenekeji sanie yano na ye sanie ni ofo yaka oba afe no kotumoboni waka the first holding any ye when ni wajeshishi ni wabon case say ni judge ni cite ni black contempt me tumobeni ke ni okoye wo sanie mi ni o town ni o prevent me ni abaye sanie odugba na mba nu amen shoduba lobo kojo sanie po biamini sanie ano no ele. It is criminal, often by a third party. See Tetegan the second versus Sapo 1973, Second Ghana Law Review 227, Rep versus Mensambunsu, ex-party Attorney General 1995 to 96, First Ghana Law Review 377, Supreme Court Atta versus Muhammadu 1980, Ghana Law Review 862. The clear distinction between civil contempt and criminal contempt resulting in the former not being crime or offense, but the latter being a crime or offense is of less importance these days, except for classification purposes. So jaja nchono kwake now. Neke nyone fe civil ke contempt fe ekwe da fe eko. You understand? Contempt is contempt. You understand? Just because I can just because I can echo me a civil, near come criminal near no eke be civil be no alo no be je contempt agboni alo be no contempt bibioni. You understand? Jeje nke wake neke nyone fe contempt ni whether criminal alo civil onyo ka ke o ene civil ni no ni civil be criminal one yenwe ni civil one yeshipon jeje ke dabi onyo ke na kan contempt enyo fe contempt ni. Lord Scarman in Home Office versus Harman 1983 1 AC 280 at page 310 said in support of the above position that the distinction between civil and criminal contempt is no longer of much importance, but it does draw attention to the difference between on the one hand, contempt such as scandalizing the court, physically interfering with the course of justice, or publishing matters likely to prejudice a fair trial, and contempt which arises from non-compliance with an order made or undertaking required in legal proceedings. In my view, therefore, the expression quasi-criminal applies to civil as opposed to a criminal contempt. So like a quasi, like a quasi jury. You understand what I'm saying? So it is not fully quasi allo quasi. It is not fully there. It is there, but not fully there. for lack of a better description. You understand? So let me give you an example. The Judicial Committee at the Traditional Council is a quasi judicial committee. I mean, your Sunday. You understand what I'm saying? But it is not fully to my high court. No, it's not going to traditional council echuni pepe no wona ba anyawo no na ba wo je court ba recognize no fe no na me ba fe to mo court we tashi ona so court we eje wale fio na ke ha the judicial committee ye traditional council ona ni ame ba nya me ye Sunday ni ka me ye Sunday ahio awo mi pepe to mo court we so na get high court any bona. I think this explanation is clear. So it's a quasi or quasi court, but you understand what I'm saying. So court to a J Waleko, they can judicial committee of the traditional council. I mean, I Sunday. I call a pepe kame Sunday. I call pepe orders now. Me I can no fair no. Keji o flat like I order say. Abanyana a fileable a chargeable contempt can no fair no. Show like a high court to me. She called to a ekpa a wale few oko they can harm. Bona nyamen tuni na kan pepe to mo court. So I think Kemita Magblami briefly Nekenji Boni. So even though there is a civil contempt, it is quasi criminal. You understand? It is not fully there. I'm using the word fully. Actually, the right word to use. But it is not fully criminal, but it is quasi criminal. You understand? Applies to civil as opposed to a criminal contempt. Thank you. So producer, I mean the right words my use. Yes, so not fully. So producer can lacks full and unbounded authority. Bona lacks full and unbounded authority. Yeah, so it's there but not really there. Yeah, so there you go. Seemingly but not quite. Producer, I mean more Nii use seemingly but not quite. Okay, so thank you, producer. Let's go. In his book, The Law of Chieftaincy in Ghana, Justice S.A. Brobe, Justice of the Supreme Court, as then was at page 463 to 462, opined that it would appear that the distinction between civil contempt and criminal contempt lies in the process of getting the contemptor to court and the sanctions for each contempt. He went on to state that the 1992 Constitution, the Courts Act 1993, Act 459, and High Court Civil Procedure Rules 2004, into parentheses, CI 47, did not make any distinction between civil and criminal contempt. That notwithstanding, the distinction may be relevant when considering the sanctions to be imposed for either type of contempt. So, a court Justice Brobe, really, there is no distinction when it comes to the civil and criminal, but nakano anya JME anyways, because keji about sanction is any anya consider whether any civil contempt ni allow criminal contempt. You understand? With regard to its quasi-criminal nature, there was this question of whether the institution of a contempt proceedings by an individual instead of the Attorney General is unconstitutional. So abiake civil contempt ni in some cases say I consider it as quasi-criminal. And keji an ordinary person keba ni J Attorney General ni keba ani nakano ani is it constitutional ani no a constitution milo ani mlani yorgan na fe ame mami ji constitution le form mlaji ni yorgan na fe ani mlani yorgan na fe ame mami ni ji constitution egmo nakano gbe ake moko ni J Attorney General ni nakamo ba anyani eke contempt charges aba against the Mokolo. So Jedi ba answer na kind no. In Aka versus Ajay Champon, 2005 to 2006 Supreme Court Ghana Law Review 1, the Apex Court was emphatic when it held that being a common law offense, contempt of court does not fall within the ambit of Article 88 of the 1992 Constitution. Hence, its initiation by an individual is not unconstitutional and void. So a court mina chole neke case ne ya wake na kan case me court ke ordinary individual can case ba a breach article 88 of the 1992 constitution no ni twanke individual ni J attorney general ni e ba ni a contempt case aba the court held further that article 1262 of the 1992 constitution killed two birds with one stone by saving both the substantive common law offense and procedure governing contempt applications in existence immediately before coming into force of the 1992 constitution. According to Professor Dateba, Justice of the Supreme Court, in the above case, this saving provision of the Constitution remains so until an authoritative change is made, and this change came later in the form of Order 5 of CI 47, which governs contempt applications. The late Dr. Bimpong Buta, in his editorial comment in 2005 to 2006 Supreme Court Ghana Law Review 1 at page 3, in contrast to Dateba, Justice of the Supreme Court's judgment, holds the view that the common law procedure by which an individual could initiate a contempt proceedings is still in force, notwithstanding the promulgation of CI 47. That procedure is constitutional and valid as held in Aka versus Ajay Echampo Supra, as stated before. So Ona Boni ate back and forth. Judge argue for and both, for and against. Ne can be nefe itaweni koni mofe mwana eni mlaka. As to what constitutes contempt, it is appropriate at this point to state that from all analysis of all legal text and case law on contempt, one common ground on which all the leading authorities stood, whether contempt of court is criminal or quasi-criminal in nature, character, or consequence, is that contempt of court is an offense. So again, look, no ni what you face, ni what blame, ni what they what bafe, no kokla chakeko, ake contempt of court, keji ofe, nakaino, eja, niesa, ochon court to a oche court to a atwa, ni nakaino, otomla, keji ofe, otomla, whether civil or whether fake way, no go you ake contempt of court, jenini. Mlaji fene kotu eke sanji fene na bote mi fe ame fe ame nu shishi ake ko cheko tu eyin atwa o cheko tu eyin atwa whichever way no ba slice ile o cheko tu eyin atwa over there ami gonti no ni ya anwen ko jani fe mo ni okinyamoko ni leun eke ha moko nya wo cha no Akufo-Addo CJ as he then was has this to say in Republic versus Liberty Press Limited and other. Ben Akufo-Addo, Papa. 1968, Ghana Law Review 123 on the issue. The courts must not only enjoy the respect and confidence of the people among whom they operate, but also must have the means to protect that respect and confidence in order to maintain their authority. For this reason, any conduct that tends to bring the authority and administration of the law into disrespect or disregard or to interfere in any way with the cause of justice becomes an offense not only against the courts but against the entire community which the courts serve. Such conduct constitutes the offense of contempt of court, and the courts are vested with the power of dealing with it in a manner that is most arbitrary. For this reason, the power is rarely invoked, and only when the dignity, respect, and authority of the courts are seriously threatened, it has been said, it has been said that these powers are given to the courts to keep course of justice free. So, look, neke contempt in akeba, aloye yamlami, boni afeni bu, ke wo, ni esani akinya court to eka akinya court to nake no ka fe ewa mamu efe je court to pe ewa mamu efe so aka ewa lene ewo court to me boni afeni mamu efe abu court to nika mamu efe bu court to ehani community efe nyon shojogba ewa community efe je ni judge se pe na ewa me ni esana abu ame ba no ba ni twenjole keni bi aba ni no nwe ehani court no chumo eyala ojogba ke ha mambiye. It is contempt of court by deed or word to scandalize the court. So I go for Baba Jono Gwage. Contempt of court. Keji oyuenoko alo ogmanoko ni eshiko tuwe be ochi court tuwe inyatwa. It is contempt of court to make statements amounting to abuse of courts. Keji oyuenoko ni abuse enle abuse yegami. Be jandwe no. Ni nakano court tuwe susunwake be o abuse court tuwe le un contempt ni. It is contempt of court to make statements which tend to expose the courts or parties who resort to the prejudice or hatred or ridicule of mankind. Nakano kaji me kome ye sandi sandi ye court na aye me kome ye nakansandi mi ni oyueno kwe nakano efeto mobo o ye sandi before e ba shemo no dani court to e ba judge alo oyueno ko ni echon agebe oyemo e for alo be o chon o e chen ni oyo kan ha mo nakano bi aminisa ni ye court nakano fe court to e here atwa chemoni. Now jejeke, having so defined contempt as involving civil and criminal contempt, it is worthy to note that as within the above types of contempt are various types of contempt which encapsulate the two main types of contempt. So jejeke wafe contempt agboagboenyo were civil ni were criminal. Shimon neke civil ne eda ni bi baba o yemi ne fi o civil le neke criminal ne le weda le undi bi baba o yemi ne fi o le criminal le. This is necessary to situate the actions or conduct of contemptor within the appropriate jacket to fit the allegation of contempt being brought against a party. So jejeke neke no here ne sani wakwa neke ni bi ne fe neke civil agbone ni bi ni yo chichife ne fi o civil le esani wakwa ke won ye contempt sani criminal enwe ni bi fe ni yo criminal le hihie le we sani wakwa ke won ye criminal le sani boni afe ke ji won boa alo won yue no ko wole atale papa ni wo ka ba wo na kan sane e ke wo yele ojogban. For this reason, I would defer to the case of Republic versus Yeboah, ex parte Nii 1991, First Ghana Law Review 587, where the court, relying on Lord Diplock's distinction in Times newspaper versus Attorney General case, said, contempt of court in a civil action is not restricted to conduct calculated to prejudice a fair trial by influencing the tribunal or the witness, but extends to conduct calculated to inhibit suitors from availing themselves of their constitutional right to have their legal rights determined by the court by holding them up to public obligation for doing so or exposing them to public and prejudicial discussion of the merits or the facts of the case before the action had been disposed of in due course. So, no, kind of as I repeat it, go take home like contempt of court. Na can call you no kone sano you no ke bamoko na ni sane ya no ke chimogbe. They fe to mo prejudiced case na ka no fe na ye ko sani atanko no me fe ka wa bumie na ye ko sani atako fe contempt ni. Again, for the purposes of the current application, the type of contempt which will be the focus of the court is the one described in Republic versus Yeboah, ex parte Nii 1991, number 1 Ghana Law Review 587 as follows. So, because of nothing blame ni me fe sane Nii Danso keba can she Nii Sempe waba contempt ni aye yes sane name Republic versus Yeboah, ex parte Nii 1991 waba kwa ne case ne ni waka ye sane ne ni waba ye ne. Now, for our purposes, as the application clearly shows, we are more concerned with the type the learned author describes as contempt out of court by speech and writing. So when I get JJ civil jamemo, she civil ni BP she. Criminal jamemo, criminal ni BP she. For what sanene ni wabaye ni wako Republic versus Yeboah, ex parte Nii 1991, number 1 Ghana Law Review 587. What about focusing neke contempt into neke context? Contempt out of court by speech and writing. So contempt no know about kwe. One kwe contempt ni aywe ye court to say ni aywe alo angma. Bona by speech or writing. Aywe alo angma. Now, no jino ni je ke ame ba kwe ye neke case ni emi. Again, see paragraph 8 of Hasbury's Laws of England, 3rd edition, volume 8. In the Attorney General versus Time Newspaper Limited case, as mentioned earlier, the law lords had the opportunity of exhaustively examining the general principles of the law on this type of contempt of court. From those two authorities, we learned that this contempt of court takes different forms. It may, as stated in Hasbury's Law of England, 3rd edition, volume 8, page 67, range from scandalizing the court itself, or by abusing parties to action, or by prejudicing mankind in favor or against a party before the cause before the cause is heard. So jajan chono kage neke mie neke Hasbury's Laws of England you are or scandalize court itself by abusing parties to actions. Ni try be parties ni your mie or abuse am based on any of you. Allow by prejudicing mankind. Once again, there were threats and all of that in favor of or against a party before the cause is heard. Before any act done or writing published which is calculated to bring a court or a judge into contempt, or to lower his authority, or to interfere with the due course of justice or the lawful process of the court, is a contempt of court. No fe no ni moko fio. Alo mo ba angma. Alo mo ba publishi. Ni eba che judge ko yin atwa. Alo eba che court ko yin atwa. Eba ni court e wala abashi. Alo sane ko yano. Ni aye ko atanko. Ni na kan no eba fe to make na ba wo sane emi. Ni alo no ko yano e court. Ni once again agbekona. Ni eba yue. Ni eba kojo. Ni eba bua. Na kan no be more eche court to here. From the above exposition of contempt, I will now look at the arguments of the parties to address the type of contempt arising from the action or conduct of the respondent. So contempt short ne contempt noni case noni no ebakwe ni ekeye neke case ne because ele susumomie sande na aka be yin efito Attorney General versus Yebua ex parte Nimete 1991 efito no pepe no ebakwe no ni ekbaye ese egbla mi ekon no ni Hasbury's Law of England no ni egbla contempt mi na ewe no ajaje ke ni nene me fe agbene sane na aka ban yin mabotemi ni ma wo sane ni nke wo neke principle na ni ma use we neke example na ni ma use we ma wo ni nke wo mi ni wa kwa ke te wo ba na sane na te. From the application, the contempt being alleged by the applicant was not committed in facial curia. Rather, it stemmed from a speech made ex facial curia. The question is, can a speech made ex facial curia be capable of founding an action for contempt, more specifically when it was made after judgment has been delivered by the court in Republic versus Mensa Bonso versus me by no go ba yin chomi ne sanin ke chombo animal cule app ni akapa no nyam once again me pa fai nyam once again ni akapa no you see, this is what happens. Okay. Anyways, I'll get back to this later. Right. So, from the application in the contempt being alleged by the applicants was not committed in facial curia. Rather, it stemmed from a speech made ex facial curia. The question is, can a speech made ex facial curia be capable allo fashi curia of founding an action for contempt, more especially when it was made after judgment has been delivered by the court. In Republic versus Mensa Bonso, ex parte. Okay, so judge you know kwake. Now, Sani na ke be here. Neke yue money aka yue. Ayue ye court to it. She ayue ye court to it say. Bona. Ayue biami ni Sani ya no ye court to again again biami na ayue. She ayue Sani say. No Sani ni Sani abi jake. Ani Sani ni ayue ye court to it say. Biami na ye Sani ata. Ni judgment to we ba. Ani nakaino esani abuno ake contempt lo bona esani abuno ake contempt lo so nakanjino ni sani ebio jeje ebio. The above question was significantly answered when the court said as follows. It was said in McLeod versus St. Alban 1899 AC 549 at 561 PC that when a trial has taken place and the case is over, the judge or the jury are given over to criticism. Consequently, counsel for the second and third respondents has contended that there could not be contempt of court when proceedings have terminated. So, a court to Sanine Ekoni Aye in 1899, Nii one of the lawyers saying they represent one party a case. Ne you know kwake. Keji Aye Saniata. Ni agbe no fe no na judge ke jury keji moko ke sane e pa agbe ye mo ye egbe na enye ejuo no ye ne ke sane na ni judge na e site na e chono gwa ke lawyer ni e defend me na ke contempt na be against am e chono gwa ke sane ayata agbe na te fi oten ni ake contempt ba ka ye sane ata na agbe na obanye no ni judge ye ko ke pa agbe ye owie jury e decision na me ba ko ke pa agbe ye owie. This proposition ignores the existence. Consequently, counsel for the second and third respondent has contended that there could not be contempt of court when proceedings have terminated. Yes. This proposition ignores the existence of two types of contempt of court. There is contempt in the face of the court and scandalizing the court, which amounts to contempt. So once again, as a contempt, you can do one in the face of the court. You can do another one, or scandalize the court. You don't necessarily have to be there. Or scandalize court. The publication in the newspaper of an article containing scurrilous personal abuse of a judge with reference to his conduct as a judge in a judicial proceeding which has terminated is a contempt of court punishable by the court on summary process. So anyway, judge and chono guake neke case no na site ni judgment ayu emyake dabi keji aye saniata. Ni still ote atase ni oyueni bi ne sa no you are scandalizing the court. Ni no keji ofe it is still contempt. Still abanya akebo aba ni akebo aye contempt sande ni akebo yone ofane jani fe mo ehami kiya moko ni lewu ekiha moko ye eshiba mi bomode ni ochu na kind no ehami. Okay, here we go on. The two cases cited above puts to rest the question of when contempt is applicable to judicial proceedings, whether the action is pending or completed. Contempt being a quasi-criminal action, the applicant must make out a case for the respondent to answer. The above legal obligation is captured vividly by the Latin maxim, Sempe necessitas probandi incumbit equiagit, meaning the necessity of proof always lies with the person who lays charges. So, in Republic versus Kumasi Metropolitan Assembly and Kojobonsu ex parte, Kobna Oben 2016, JELR 660669CA, the court emphasizing the need for establishment of prima facie case said, contempt proceedings are quasi-criminal actions and the applicant carries a burden to make out a prima facie case of contempt before a court can even invite a respondent to answer the charges. A proof of any allegations of the acts which are contemptuous must be given beyond reasonable doubt. So, neke case na any judge is cited holding any onayeni no. Yes, because contempt is quasi criminal. You can still treat it with a criminal case. You understand what I'm saying? Before na criminal case go by a court about charge muku with criminal case no actually prima facie njino kwake on the face of it you should be able to tell an offense has been committed kemoko ba neke ni tete egbe twe obejame shike okwemo yin esa no li akelele mene eyin nchon ake ajegba gbe twe ekola nine epetegeme ni ona mark say ejeme ni gbe twe eyin egba lan chocholo mi enemy abo basic example you understand kono primary facie shishin so because once again keji mo ke ba de twan ko gbe twe beje no aye onyo koju aka o lele mene gbe twe agba ya court na bona she before na agba court ni lele akwa aka o lele ashimashi na gbe twe she mo na moji mo ni gba twe it's an na primary facie it's an na onoli aka lele agba twe. You understand what I'm saying? Nakano every criminal case nakanjiboni you, and of course you know the standard for criminal cases the burden is on the prosecution to prove beyond reasonable doubt. But in civil cases it's on the preponderance of the evidence adduced before the court. So no, you don't really have to prove beyond reasonable doubt. But because this is quasi criminal, so I treat the like a criminal case. No, need contempt name. So one. A prima facie must be established. On the face of it, there were questions here. In this case, noni what I need and so keba belela ke Nii Otinto ejwe alo efe. So that prima facie must be established before po jeje ba consider nakanji noni onane. Any proof of any allegation of the acts which are contemptuous must be given beyond reasonable doubt. Once again, that is the level for criminal cases. You must prove beyond reasonable doubt. So, any unchono kwake, jeni oke prima facie umpu baba. Shiwake prima facie bangwe. Esanye lewe onyeni o established beyond a reasonable doubt. Just like any criminal case where the prosecution has the burden of proving the crime was committed by the accused beyond a reasonable doubt. Nakano is any lawyer ni a representative or applicant. Leun ke I may establish prima facie atan. They should be able to prove in court indeed this crime was committed by so and so beyond reasonable doubt. What was the grounds for invoking the present charge against the respondent? So many ground there agbene ni akeba. According to the applicant, the action or speech of the respondent constituted one, an intention not to accept the decision of the court. So, Nii Danso tawo ne chon, ni ne wo ne sane establish ni chuangelele, Nii Otinto echento court we nyatwa, ni lele we sanaba na ke content amole. Ke ekono Nii Danso yue, be Nii Danso ta ne chuanke, Nii Otinto efe yake, decision ni court keba ekechuni. Defense of the order of perpetual injunction granted by the court. In Kebwake, Nii Danso ne win na can court ya high court. One of the things ni a seek was a perpetual injunction preventing Nii Otinto from ever going to the 14 acres of land na chon. Ya Nii Danso smomie eke contempt eba because one Nii Otinto efe yake no ni court you eke chuni agbeno bechini ni court eke meno ake eka chone ke shikon no ke we be Nii Otinto efe yake na kan no we ebotwe na kan injunction ebotwe na kan injunction ake meno ha katabia meni is perpetual continuous katabia meni sane e ba gbeda ni sane ye court tolo na kan injunction de mo no be Nii Otinto efe yake da bi ebotwe incitement of violence against the four plaintiff be e tawni wome wale boni afe taflache violence ye gamie mini afe yaka noko eshi the fourth plaintiff, in this case Wache Nii Danso. The conduct of the respondent is a deliberate attempt to bring the authority of the court into dispute and to incite disobedience to each judgment. Okay, none in your thing to fear. But etan efe yake eke court ten ba tumushi e wale ni court to yo ebu ni etan ni mu femu aka bu court to I have looked at the speech in its entirety, and I have no doubts that it is in relation to the judgment delivered by this court on 13th April 2025. So, Ibo noni Nii Adote Otinto yue yana kengbile Ibo yue mo fe twe ni ya min susumo miye mokonya jewami ake noni wache Nii Otinto yue yue sane ni ya judgment ye no yue na kan no. Following the judgment, the spokesperson for the contempt law issued a press statement which sought to clarify the decision of this court, and the respondent speech followed on the heels of the statement made by his own spokesperson. So nyabaka yake biamini judgment ba wanyeme Sempe me amefe press conference first. So ke yele susu mami ke buene me fe Nii Adote Otinto nye ka ke yue mo ne yue e call judgment na ha e ko because e be na kan case me e ja ke na gbe na na yue lo ba yue hale ye ne ke sane ne here ni no se mi danile wache Nii Otinto e ba dumoshini e yue no na yue. So there is no way ni ameba ka ke no na me yue e call sane ne ko. There can be no doubt as to what precipitated the speech of the owner. America easily. The speech of the respondent, and it is the judgment of this court which was delivered after 10 years of litigation. However, the pertinent question that one may ask is, did the speech constitute disobedience of the judgment or order of the court? So, look, no go grab ni obanyo yuake nege yue monena yue eba because of judgment any court after not a court for 10 years. Shimon Sane ne esani wabi jiake and in what no Nii Otinto yue and in no eche court to a year at one low. I know not of any law which forbid a party or a member of the general public to desist from commenting on the decision of the court. Nyemeni inko nyake nyemeni ka feka min fe neme nye batabie ninye yuo inko nyake nyeleni read gidi thank you. So violence said gidi thank you His Royal Majesty get violence said word for it is gidi inko nyake nyeleni. I am not the repository of all knowledge. I have never claimed to be. See, before me sometimes you look, I'm not beyond reproach. Chastise me all you want. Call me out of my misdeeds. You have every right to do it. I said this the last time. The only platform it means I'm doing something extremely wrong. People must disagree with me and call me out and say whatever they want to say, but make sure when you are calling me out, you are right. You may need judgments come in, me chastise some of the judgments, me re against it, me no, and then be as an judge consider ne consider in your call, ni Sania FN again, you can't young man, you can't if you never let me. In Yako law school. I'm not a lawyer. I wish I am. When you read a lot, news some of these things is basic. You will know. Google is free. I know not of any law which forbid a party or a member of the general public to desist from commenting on the decision of the court. When you know some of these things, you know the line. Lay coming cross over to contempt here. I know. I read that news. I'm a queer news. I'm a queer news. So the many sometimes I can't type in. I just laugh at you guys. Well, I said, no, but bring it on. And when you are bringing it on, you make sure you have money. Because I will counter sue you for wasting my time. So bring it on, but be sure you will win. My name judge bribe ye. So follow le no baby. You can come from Ghana and sue me. But no sue me. But sue me. But make sure you are right. Ma counter sue boni o shamon pulu fe ma yodi. Because call wasting time, you pay for it. Call next time on a jum. Judges, like any public official, are not immune from criticism. In Ambart versus AG of Trinidad and Tobago, 1936 AC 322 or 335, a case relied on in Abu Ramadan and Gary Nimakun versus Electoral Commission and AG in RE. Number 1, the owner of the station, Muntie FM. 2, Salifu Masi versus Mugabe. 3, Alista Nelson. 4, Godwin Akogan, a case formerly known as the Muntie 3. Lord Atkins said, justice is not a cloistered virtue. She must be allowed to suffer the scrutiny and respectful, even though outspoken, the comments of ordinary men. In Republic versus Mensamboso, ex-parte Attorney General 1995 to 96, First Ghana Law Review 377, the court was emphatic when it said, the law permits some amount of criticism of a judgment, order, or pronouncement of the court, but such criticisms must be made in good faith, devoid of malice, and in temperate words. Analyzing the speech from the viewpoint of disobedience of the decision of the court, I could not discern any part of the speech where the respondent advocated for disobedience of the judgment of the court. Kajimbo, noni wachani otinto yue, ina ekopoten ni wachani otinto ke noni jeji, noni court to yue moko ke kachuni. Jeje ke dabi, inu yemi ake wachani otinto kake, noni court to yue ake kachuni. All I can discern from the speech is a party who is dissatisfied with the decision of the court and is expressing its opinion. Simon, noni manyama ke jiake, minna ke, ejimoko, ni kotu make a decision ko, ni nakaino, ekepagbe, ni yuake, noni kotu yue, ekepagbe. Kewa ye yake nakainoe mlako be against the nakainoe mlako be. Though it did not refer to the judgment, its references to the case of Jamestown 2 versus Sempe 2, a case which was one of the paramount cases which was one of the paramount cases relied on in this judgment of this case, did not come out of the blue. Even though a case in a potent time ne yue echi sanekonaye between Jamestown ke Sempe stool ni nakaino miye akwana kansane ekono ni akaye sanene no wona kan case ya no keke. It is the knock-on effect of the decision in suit number FAL/111/2015 entitled Dan Nii Danso versus and others versus Na Akushika Omedro and 3 and others. He caused his spokesperson to react to the judgment in which Nii Danso II won, and the speech was his response to the service of the entry of judgment after trial in the media and on the land, including his palace. She face now be now what Nii Otinto a spokesperson by you. Ni no ni by you after next spokesperson by you the same sanye ni what Nii Danso yelehi ni enter entry of judgment. Agbe no friend akawo media mi no friend I publish akesane wo aye against Nii Otinto no me ba you na ni be fe apete palace fe. However, there was no direct instance of disobedience to the judgment of the court in his speech. Simon you any fame Simon no go kwa poten be ni what Nii Otinto you echi judgment ni je ko court ne tan ni eka mokomoko aka bu neken judgment ne. The respondent has the right to express his opinion about the judgments of the court. Nothing to ye egbe ni ka ye sande ni eke court to ekpan gbe ye egbe ne yuo moko kla echi legbe moko kla echi legbe. So yue mo ni otin to yue le moko kla nye echi legbe esa aka yue ye egbe ne sane yue mlanmo legbe ne sane yue ni jeme etonko aka eba yue no ne yue jeje te no ne yue ake. The above notwithstanding, Shimon yene face Nii Adote Otinto inchin le ba keke judgment kweba ne kekpa gbe eyuehe ne express opinion against nakan judgment chin legbe. It is in his right to do that. Mlakokla be ne chion legbe aka you third grade blofobi nye buatwe third grade blofobi nye buatwe mlakokla chin legbe eye egbe no ni Nii Otinto yue esane yami 3D Kenyan judgment ne ngwe na eye egbe na ekọ aga no ni yu egbe na Shimon sane ebie. There was specific reference to the said Nii Danso II, and there were portions of the speeches which sought to denigrate his person. Shimon ya yuemo ni mla echi legbe yuemo ni esa alo eye a right mi aka ba anya yue na kan yuemo na yue ya yuemo mi yue noko eshi wache Nii Danso ni jienwe kese ni wache Nii Danso tano ni na kan no ewo wache Nii Danso emuji ni ewo esene tano emuji ni ewe ku emuji, and his family history coupled with threat to his very person should he attempt to execute the judgment of the court. Ewe emuji ewo se emuji ewe kuma emuji agbene nwe a threatening le tumobe no olue keji amenta na me yo mo ameta amehia na me ye pepu ka me na ne maja ma crash ya me fe. So jeje ke na kan yue mo poten le eyue Nii Danso ke se ne ta no ke eyue Nii Danso we kume agbene nwe a threatening nu ake keji Nii Danso echonje me alo no ni court we ke e kan choni e kwa chuni wacha Nii Otinto e ba crash ya me. Now, statements such as when a judgment was pronounced, Nii Danso's father was not present in town, having not yet come from Ikwapim. Consequently, he has no jurisdiction over the land where he rules as a chief, which rightfully belongs to the Sempe stool. I will not tolerate anyone from Ikwapim claiming gallant. There is no way I'll permit that. JJ, no ni what candy or no can't feel video. The whistle. Please see if you can find that full video for me. Nanima track before about this. Again, this is a demonstration. Come back and I can audio video. Me no mani audio toge. Le Nii Danso nakan sani abena ye no me che ejako ene jeba. Pona baba for me can be against Nii Danso papa and all of that. You know no ni je. This is a demonstration of non-acceptance of the judgment and an intention to dampen the effectiveness of the judgment. Jajake neke yuemo echonake wache Nii Adote Otinto efe ejomoake judgment ni akeba eke chuni ni eba fe no ni eba fe ne ani neke judgment ne efe bibio eke jaje tenu ne eke though intent cannot substitute for overt act. Its introduction is to introduce the element of overt act of preventing Nii Danso II from enjoying the fruits of successful litigation. Yes, even though Bomoyito, Anyeni Akachake noni Bomofio, or into a yoichomi, again no konofi, a yoichomi. Even though Anyaka Yito, Achake noni Bomofio, Kejimoko, Ekanaka ba. Ni chwange mon town ni fe noko ni wacha Nii Danso ni te court to for 10 years ne win ni nakai no echilebe ni eka enjoy nakai no. In another statement contained in the speech, the respondent advocated violence. For the sake of clarity, the statement is reproduced as follows. Jaja nchono kai yanaka video mi no ni wacha Nii Otinto yue wacha Nii Otinto ntaw na echa gidigidi femu echa gidigidi femu keba jaja ke koni ona no ni nchodo gba anima koti no ni wacha Nii Otinto yue. Again, I urge Nii Danso and his people to respect our traditions because the land on which they are belongs to the Sempe stool. We celebrate Omo, but they don't and must henceforth refrain from sprinkling pokoi on my land. If I ever set eyes on them doing so, I'll crush them. If they wish to eat pokoi, they should do in the privacy of their own homes. So, onuni jeje noni nkebo elia ekotu na pepe. Akenokeno kwe wacha Nii Adote Otinto ne kebia ne yue be echa gidi femo kemba ninue esa. Now, one may ask, what crime has the said Nii Danso committed to merit such denigration of his person, stool, and family? Mogobabiake, Nii Danso mini pote efe, ninue wasana we muji, nia wo sene tano emuji, na we kuma efe emuji. His crime was to exercise his constitutional right to use the medium of the courts to ventilate his grievance. Etomo no jiake, ete kotu, ni kotu aye saniale, ake no go yele, neja. No ete kotu ni kotu aye saniale no twanke ayue mo na akba wo emuji alo akba wo eweku emuji ke sene tano. What is more, he has won a case against the Sempe Mantse, who obviously was relying on a grant from the respondent. Judging from his speech, the applicant was being disparaged for exercising his constitutional right to submit his grievances to the shrine of justice and not to the shrine of traditional authority. Ake be wache Nii Danso inagba no jiake alono ne fe ni wache Nii Adote Otinto susumomie eke sanie ete mlayeli na yale ni noni ekola ba ke yakusungbe na ebuo no to something like that. I don't know what to expect. I think you get the brief. The question at this juncture is, do the above comment constitute contempt? So yeah by ebisane. So nibi ne kan fe aboe ani wabanye wakake lele Nii Adote Otinto eche mlaye atwalu eche kotu enye atwalu. To determine the above question, the authoritative statement of Lord Diplock in the Times newspaper case Supra at 309 to 310 will serve as the yardstick. So neke case ne boli akoti omo kajeshe ke waba yusu no nino adirect wo nino ajaje wo nino achose wo whether noni Nii Adote Otinto ewie na efe lele ake ebanye efita abanya bulefo ake lele eche kotu enyi atwalo. The due administration of justice requires first that all citizens should have unhindered access to the constitutionally established courts of criminal or civil jurisdiction for the determination of disputes as to their legal rights and liabilities. Secondly, that they should be able to rely upon obtaining in the courts the arbitrament or a tribunal which is free from bias against any party and whose decision will be based upon those facts only that have been proved in evidence adduced before it in accordance with the procedure adopted in courts of law. And thirdly, that once the dispute has been submitted to a court of law, they should be able to rely upon there being no usurpation by any other person of the function of that court to decide it according to law. Conduct which is calculated to prejudice any of these three requirements or to undermine the public confidence is contempt. So, noni onanin kanefe yes, nekeni bi etene keji moko fenoko ni you can tell like it is a calculated attempt ni be eba check out to enya to alo eba ni me akabu court to na kano obanye what contempt ni. My lords, to hold a party up to public obloquy for exercising his constitutional right to have recourse to a court of law for the ascertainment and enforcement of his legal rights and obligations is calculated to prejudice the first requirement for the due administration of justice, the unhindered access of all citizens to the established courts of law. The transition of man from the Obitian society characterized by a survival of the fittest to the Roche society, where law and order prevailed and life is sustained within the parameters of law and order encapsulated in a document known as the Constitution, marks the evolution of primitive society into civilized society. Yes, wanyeni wai chuchuko the options nine when it is the survival of the fittest. Biane wa move na kaino wakeba any akemla chuani bonia fe ni wafen wa inshu ojogba as civilized people ejiewo keje me kome ni ta flache amenye chela ame keba me ni amenye chelo ame. A constitution, in my view, and for the purposes of this application, is a document which is evidential of the surrender of the rights of the citizens to the supremacy of law that will regulate their lives and ensure freedom and equality. In his book, Without Precedent, Joel Richard Paul, quoting John Marshall, the longest-serving Chief Justice of U.S., said at page 256 that the Constitution was her form of law established by we the people rather than mere legislature. The Constitution vests the court with powers to adjudicate disputes between the citizens. Article 125 of the 1992 Constitution is explicit on the said power when it provides that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. The judicial power is to be exercised by the courts and to ensure that it is not interfered with and untrammeled by any authority. Article 1272 of the 1992 Constitution wrapped the said power in bulletproof provisions as follows. Again, neither the president nor parliament nor any person acting under the authority of the president or parliament, nor any person whatsoever shall interfere with judges or judicial officers or other persons exercising judicial power in the exercise of their judicial functions, and all organs and agencies of the state shall accord to the courts such assistance as the courts may reasonably require to protect the independence, dignity, and effectiveness of the courts, subject to the Constitution. Why the above provisions? The court in the Mantse 3 case provided the answers as follows. The reason is simple. In order to sustain the democratic system of government established by the Constitution, the judiciary is the arm of government which has been given authority to police other arms. That is, the executive and legislature, as well as all governance institutions. The court is therefore deserving of the utmost respect and reverence if our democratic enterprise as a nation is to succeed. Through the surrender of their rights to the Constitution, the citizens, be it the ordinary man in the street, a politician, or a chief, are mandated to accept the status of the court as the final arbiter of disputes. Constitution no fe no ni mla ba yue isani wo fe mini wanyeni wayeno. De sani wayo se ake keji sani ba ni ake te court yen ni court yue pe isani wo fe mini wo mommy. The implication is that decisions emanating from the courts are to be accepted by all, no matter the dissatisfaction or grievances one has with the decision. Ake ni wo fe wa yake wo ba yimla kome hihie no ele ka ke sanete court ni court ayue whether osumo alo osumo o esani ohi abomi ni okechuni. Having said that, it does not imply that the decisions of the court are immune from criticism, protest, or scrutiny. No echwa ke dia ayue no ko ni okepa agbe keje court e be onyo yue o ba nyo yue o ya egbe mlechi bogbe akoka yue o ya egbe ahun no yue o ya egbe ahun no criticize o ya egbe ahun mlechi bogbe. It is to safeguard the powers of the courts that it has been vested with powers to punish for contempt when its orders are disobeyed or the administration of justice is interfered with. Shimon, ake ni wafe wanyeni waye court to waye ni kaji yuwe no ko wafe wakachuniye ne wani asa ale ewale ake kaji yuwe no ko ni ofetumo oyue oshiko to alo de no oyu oshiko te oyue no ko ni nakan no alo ofe no ko ni nakan no eche court to yin atwa court to wo shinko ni nakan shiwe oye no ni oyue no ko eshino ni shie ni court to ewe benuele esani anya punishable boni afe ni nakan ewale ni wo fe wo ka wo court to emi mo fe mo ahye nakan no gbe yi e ga ka afe nakan le be mo fe mo ba anya fe no na esumo keji akesane te court ni ayue no go de esumo mo fe mo ba anya fe no na esumo. See Article 1262 of the 1992 Constitution. Again, we live in a season characterized by freedom, where every Tom, Dick, and Harry in this nation of ours is breathing an air of freedom, which is unprecedented. This should have been exciting times for the people of this country. But what do we see? A season of rage dominated by unlimited access to the social media. Jajan chono wake ya gana wafe wa ya jole wa ya mankoni mo fe monye yu no ne sumo ni mo go gba una ni esani wanye wabuna kan no ehino mo won fite mo because wafe wa ya social media ni wafe won fefe no ni wosumo ni esa ni na kan no e baale na kan botui again a nation where individuals and in some instances chiefs take to the social media to spew statements which do not stem from mature leadership and which statements tend to foment controversy, undermine individuals and institutions whose role is essential to cohesion and harmonious life in a civil society. Ike what choma wa man where ni mofemo nye tioshi es magia cheme ko no pa ni mofemo ya social media na you no na sumo ni na kan no wa e kome femo shimomo efiti oni bi blama hie wo ma emujie ni institutions ne sani mo amewa one fite na institution the situation has reached its alarming proportion to the extent that the courts have not been left out of it. Neke no go nete no anwa ke court to efe un podi enche a bombo klati court to di efe. Yeah mfo ya me. Yeah social media wo a bombo klati ame fe ne sa na bombo klati ame. We are confronted today with a scenario where a chief, to be precise, the Mankralo of the Gun State, Jeji, I better go naturally the Mankralo of the Gun State, Jeji, I better go na kai. Over next time, Kangmana kai, Kachake history, Wabe Mankralo, Gun State, Wabe Mankralo of the Gun State. I am Mankralo, Benayo Trinity. It's not for the Gun State. It's for the Jamestown, English alata, the Trinity. Biana na Trinity, so abe man kralo sempe your man kralo ni English alata your manche na kanjiboni amejale bia ne na gano ebe wo be no go na chole man kralo of the Gun State Papa Jeji wo be no go na chole na kan in the person of Nii Adote Otinto II has been hauled before the court for contempt in respect of a speech he made on the commemoration of the demise of the late chief of staff of Sempe. The issues emanating from the speech and action of the respondent is as follows. Boli, court to Sunday, jeje, ese repeat eko gagbene eke final ni ne eba. So question as an abine. Did the speech denigrate the person of the applicant, his tool, and family in the exercise of his constitutional right to ventilate his grievance in the court of law? Jeje Bisandi. Did the denigration and attack on the applicant for exercising his constitutional right to access the courts constitute an interference with the due administration of justice? If so, did the interference with due administration of justice constituted contempt within the criminal case? These issues are crying for determination in this court, and the court will not shirk its responsibility to determine it for, as was said in Republic versus Mensah ex parte AG. Let us take a minute. What? Let's take a minute. We'll be right back. Enjoy this one from the great Wulome. Shout outs to America. Shout outs to I thought Bobby, you need your nickname. You say Niamo Pacha, I mean, Pano. We'll be right back. Ofane, Johnny Famwe Hami, Kiamoko, Nilewu, e Kiamoko. Wabaku was say, Waba, no, I mean, 1 second. Let me project this whilst I take a breather, and I will be right back. Shout out to you, John. Ofane be oyojuba. Ofane like mo show me. Johnny Femo Kiamoko ni Okiamoko. Shout out to Numo Ashite. Numo Ashite. Shout out to you. Numo Ashite. What Dabi Israel Majesty. Dabi Omisiko. Producer ke wafele in 2 weeks. Bona. It will be a Saturday program. So producer ke working me in 2 weeks. So Omisiko. So 2 weeks from today. Obafe nakanshowe. Bona. 2 weeks from today, Obafe nakanshowe. Hello, there is Jena Goge. Shout outs to you, Numo John. Numo John is in the building. Numo John is in the building. There is a over a fella in 2 weeks. Hello, Jena, Nika wrong information. Fine it. Over me at the other side, text mommy. So you might just screen there, no text mommy with the answer. Yeah, Ishibani. I'm going to the other. All right, here we go. So let's go on. Again, to refuse is to resolve is to refuse to resolve this fundamental issue, and whatever guise, subterfuge, or pretense may lay the court open to a charge of running away from the truth, which we are not entitled to do, and expose us to ridicule and contempt in the eyes of the public. I have already stated that the speech was in reference to the decision in the court in Nii Danso and others versus Na Akushika Umadru III, Sempe Mantse, and 2 others, which decreed title to 14 acres of land to Dansoman to at Dansoman to the applicant. The respondent was adamant that he had no notice of the judgment, and therefore the speech was not in reference to the said judgment. This defense is unsustainable, and this is because following the judgment, it caused a spokesperson to issue press statement in reaction to the judgment. So, judge and Chodogwake, look, yes, Sanene na yeah. Okay. If I nyama responder to producer real quick. So judge and Chonogwake. Yes. Yeah. Okay. Yes. Yeah. So His Royal Majesty. In 2 weeks, Bona. 2 weeks from today. Producer I confirm. 2 weeks from today. I can show it. Bona. So Kayochi. 2 weeks from today. Ibabano. I can show Ibabano. Producer I confirm. So again. Yes. Even though Nii Adote Otinto ke sanene bemi. No judgment na ha. Enukole na kwe. Yemi na kemo ne Shimon ni agbena wache Nii Adote Otinto a spokesperson by way onu shishi so ne spokesperson by way yes sanene here enye kake elesane eko. You see why ni and that reminds me, you see why ni some of us say we did not agree, and I understand. Look, it's nakanjiboni law yo ke o follow cases ni ya court sec and can be obana that is why we disagreed with the fact that the Supreme Court take care ni interpretation Kevin Takike ehankole ewale ake ebayue. Oh yes oh Impapa, yeah, Impapa. In Lage Mogone, yeah, that's my pops right there. Yeah, the whistle, yeah, that's my pops. So yes, on and on what some of us say, what we are not know what can be bona. So here you have a judge saying, okay, Nii Adote Otinto, yes, even though a beneke sanene na ye, a spokesperson about face speech. Yeneke judgment ne so enye kake judgment enukohi ni eleheko. She te fiote na Supreme Court Kevin Takike echuko Esenche has been fighting for him all this while. She na Supreme Court ege echukole ni Supreme Court be a here awoni. You see why nakan judgment what you she nakan judgment it does not make sense. This is a judge saying, okay, spokesperson. Ni you can say, okay, traditionally, the whistle, is there a traditional role, position for spokesperson? Obaka or Chami, right? She Nii Adote Otinto a Chami pony by free nakan show it, nakan press conference. And triangle, yeah, Chami any. You understand what I'm saying? So you cannot say, okay, Keji Manche. Esenche ba e baba ne beba ke boake sani ele eko ne chukule no ba hoye. So that's decision from the Supreme Court. It's flawed. It makes sense. It makes no sense whatsoever. It makes no sense. Ake senche beba dumoshi ni senche ba ake senche ne win ne na me win ke senche all these one na win no na mo ba benefit. E ba benefit e manje. So me no can no go against the Senche, manche, but once again, that is law for you. Lawyer for there. No, I can't here bush. So judge and kaga, Nii Adote Otinto kaga she ele again dabi because any a spokesperson by you. No any spokesperson by you. If you tell no baga ole eko na no dabi anya ke tuning. Also, the judgment was served through substituted service on his palace and in the media. Yes, na kan judgment there when ake wo media mi ni mo femo na ake sane ayeshi Nii Otinto aka pete palace hu. So there is no way Nii Adote Otinto ba ake neke sanene eleko. The question is, if he has no knowledge of the judgment, why would the applicant, someone who cannot be at parity with the position of Sempe Mantse, be subject of his speech. So, great question. Judge ne a drain, judge ne a drain, judge and drain. Judge, he can near take a son and a judgment, dear Leco, near Echo, near spokesperson here by you. If you're 10 in a year, near director, you more a sure what you need and so. Ni trage, belle, Sunny Echo. On a judge Ebisani. Judge Ebisani. If you're 10 or quack or Echo, or spokesperson here by you, or Leco. Kawaje memo shino ba you o yoshi moni akesane etenile awi ni moni kesanete ni twage oye abwe neke questions is an Supreme Court judge say amebi Kevin Taki lawyer akese ni senche ebe peli oye na motasen no moni tasen no te fi o te ko ake ele ko aka kesane ete court yesen na etano yi on a Supreme Court judge say last year these are the questions this and maybe monita say no ke senche eba court we yes say no apele say ye na gele echugo senche ni nye here woni oh so jeje you ake e go le ekwe if you te manche ni a manche yelie e dafebo it is not in parity with your position kaboye gbopo in other words o sen dafe say if you te no one speech in US ani the applicants will not be subjected to attacks and personal denigration if not because of the decision in Nii Danso and others versus na akushika Umedo III and two others dabi nege no gone ye kejije na kane esani Nii Adote Otinto yuo no kokura na ewuo Nii Danso ke muji ye neke sanenemi dabi no elengele kpagbe. Every occasion will invite a language of appropriateness to the occasion. The language that the leader will use to address the state of the nation is not the same as will be used to address a nation which had lost its sitting president. The kind of language that will be used to address a nation on the swearing of a new leader is not the kind of language that will be used to address a nation at war. There is a language of prayer and a language of love. There is a language of anger and a language of rebuke. And there is a language of reconciliation and a language of retribution. And there is a language of peace and language of bereavement. The statements made by the respondent was at a pre-Omar walk organized in memory of a late Sempe Chief of Staff. The one may ask is the statement made by the respondent connected to the festival of Omar or in memory of the late Chief of Staff of Sempe? So okay, Nii Danso sano you no go pako ye afene work na te ni akenkai bo Chief of Staff and in aken particular you mo na kan know o Chief of Staff is an you. I wish I could the judges your Supreme Court na meta Kevin Taki no naked say shirari and naked there no I mean baby neke question say I mean baby neke question say I mean baby. The tenor of the speech was directed at applicants for exercising his constitutional right of unhindered access to the courts. To attack and denigrate the applicant, his family, and his tool is to send a defiant message to any person who will resort to the court in any dispute with the respondent in his position as Sempe Mantse, as regard lands, which in his view is Sempe lands. A clear case of interference with due administration of justice is apparent here. Words like ceremonial chief coming from a kwapim to take gallant must henceforth refrain from sprinkling pokoi on my land. If I ever set eyes on them doing so, I will crush them, are the words of a bully. Hey, 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 hey. Nyekwano ni jeje yue bie jeje na eshemo mo gbe eshemo kura gbe jeje ke maka na egwe botu. Shout out to you okanleche boy ojugba jeje ke words like ceremonial chief coming from a kwapim to take gallants must henceforth refrain from sprinkling pokpoi on my land. If I ever set eyes on them doing so, I will crush them, are the words of a bully. They are words of a bully. Nii Adote Otinto no two, he is watching. I can guarantee you 99%. Nii Adote Otinto he is watching this show right now as we speak. He is watching. Wow. Yay. Yes. These words. Again, these words, aside of the fact that they incite violence and to mobilize mankind against the applicant, they also demonstrated lack of decorum, ignorance of the maker of the speech of his own history for the Jamestown Alada stool, which consists of his stool and other two stools, was founded by Wechekojo, who came from Alata. Oh, yeah, ouch, 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 ouch. Nii Adote Otinto. Yeah. Emma, Nii Adote Otinto ma wu atole. Emma la atole ge take him a hook nega wo ma wu bigbi. Ni miniano nkenga bo e fine. Ani moko lakabo. Ni nkebo ye fine. Nge bo e ko yue. Mi ile manchagoni ge yue gan bo le to etumo boyi. So me nkebo e fine. We're fine, and that is why it means sumo ake going forward there. Oba correcting ni bi ni wo fe ni bi ojogba ni wo ya no kwale ni wo ka no kwale afon ina san ni wo ka no kwale afon no fe no ayale ojogba oblanta ya me buobo to ewa kok ona jeje you ake oyi wale no yo kok atashi aba atashi. So you need to use that power ni okuba sag ona currently ele nakano le in alojuba oda be currently nakano na alojuba nojino kome ni gbanna nojino kome ni gbanna ke you've been put in a position where you can use it for a greater good, and as far as I'm concerned nowhere ofi una boni yo and gbanna. And I hope, as you listen to me, Obinu, I hope you will come to that realization very soon. Because Ganya, Bona, you will come to that realization very soon. Ni ofe no ni esani ofe. Anima kunze maya jeme kun. Jaje meng mawu actually. Ama kande kun. Words like ceremonial chief, coming from a Kwapim to take gallant, must henceforth remain from sprinkling pokpoi on my land. If I ever set eyes on them doing so, I'll crush them, are the words of a bully. These words, aside for the fact that they incite violence and to mobilize mankind against the applicant, they also demonstrate a lack of decorum, ignorance of the maker of the speech, of his own history. Nii Otinto no you bolenche olenye history ojugwa nagenje keje minke ege ole be bolenche olenye history Jamestown Alata stool be bolenche which consists of his stool and other stools and other two stools, was founded by Wechekojo, who came from Alata. Bien en chonge je ngom ma wa tole go yin pa no age Wechekojo ni le yo English Alata manche ni bo oyo man kralo ke ha Trinity Wechekojo le nche ja Alata no te fi oten ibo mo no manche ni oyo man kralo ke ha le e ja Alata no te fi oten ni okom wa ge eje kwapin de be ba ko gan shipon ni twage bo lenche olo history ojugba je ke je minke je mi obile dabi je minke. Again, once upon a time The Sempe and Akomaje lands, collectively known as Latabiokoshi lands, was under Jamestown Alata Manche. See Jamestown stool versus Sempe stool. Why was Wachekojo not denigrated for coming from Alata to claim Sempe lands? The simple reason is because Nii Danso II is a sub-stool of Jamestown Alata stool, as exercised his constitutional right to ventilate his grievances with respect to 14 acres of land in a court of law against a queen mother of prominent stool such as Sempe, of which the respondent is the custodian. The purpose of the speech to subject the applicant into public obloquy. I have no doubt that the above words are spoken deliberately and willfully to demonstrate to the applicant, despite submitting his grievances to a court of competent jurisdiction, which culminated in a decision in his favor. Any attempt to enjoy the fruits of that victory will be restricted to his residence and not the land adjudged to belong to him. So once again, if you tell them, okay, Keji, I'm coming and my gem about crash, I'm come by a quick way, I may ya machine jammer, no jaja trunk, but no come, I come victory and I'm a time to me now, may in I know you cannot do that. This in effect constitutes an interference with the administration of justice in Republic versus Liberty Press Limited and others. 1968 Ghana Law Review 123 at page 135. The court, in elaborating on the offense of interference with the due administration of justice, said, the important position of the judiciary in any democratic setup must be fully appreciated, performing, as they are called upon to do, the sacred duty of holding the scales between the executive power of the state and the subject and protecting the fundamental liberties of the individual. The courts must not only enjoy the respect and confidence of the people among whom they operate, but also must have the means to protect that respect and confidence in order to maintain their authority. For this reason, any conduct that tends to bring the authority and administration of the law into disrespect or disregard or to interfere in any way with the cause of justice becomes an offense not only against the courts, but against the entire community which the court serve. In Republic versus Yebua, ex parte Nyemete, where the court speaking through literate justice, as she then was more opposite, said, contempt of court in a civil action is not restricted to a conduct calculated to prejudice a fair trial by influencing the tribunal or the witnesses, but extend to conduct calculated to inhibit suitors from availing themselves or their constitutional right to have their legal rights determined by the court by holding them up to public obloquy for doing so or exposing them to public and prejudicial discussions of the merits or the facts of the case before the action has been disposed of. What can earlier? As I repeat, the freedom that we are enjoying today created the enabling environment for the chiefs in the position of the respondent to thrive and perform their role as one of the institutions of governance in society. That freedom is not freedom to use speech to incite violence or to cow subjects or custodians of substools into silence, or into fear of exercising their constitutional rights of submitting their grievances to the courts of law when the need arises. Amwasechi, Justice of the Supreme Court, in Republic versus Mensambuso, ex parte Attorney General, as stated earlier, reiterating the above point, said, under our Constitution, 1992, the right to freedom of speech and expression may be curtailed for the purpose of safeguarding our people against the teaching and propagation of doctrines which incite hatred against other members of the community. What may be described under this head are religious and political doctrines which tend to divide the nation and turn one section of the community against another. The provision does not sanction the curtailment of the right to freedom of speech and expression for the purpose of maintaining the dignity or authority of the court. The same freedom of expression enables one to use speech to criticize constructively any act or decision of any public body or institution of accountability. The courts are not accepted. The other side of the coin demand that the same freedom should be used to accept graciously the decisions of the court whilst using the apt legal process to challenge the decision if one is dissatisfied with the decision. And this is a step Nii Adote Otinto take. This case is in the Supreme Court. Abaye a stay of execution pending the appeal. I have that here. We'll go into that. Abaye is Supreme Court. Final judgment. You understand what I'm saying? So there is no need to go around threatening people, denigrating them, whilst you are taking the legal course. The current and immediate past president of the Republic of Ghana both lost election petitions in the courts of this land, and they both accepted the decision with magnanimity and grace. Though they were disappointed with the decision of the courts, they never organized press conference to incite their supporters to violence. That is the hallmark of responsible and mature leadership. The legendary boxer Muhammad Ali epitomized this virtue vividly when he tasted defeat for the first time in 1973 against Joe Frazier. He spoke, "I never thought of losing, but now that it's happened, the only thing is to do it right. That's my obligation to all the people who believe in me. We all have to take defeats in life." The need to do the right thing is the obligation the respondent owes to all his subjects after the judgment of the court. The Constitution guaranteed freedom of expression, but there is a line where freedom of expression should not cross. And according to the court in Mantse 3 case, this is encapsulated in Article 41 of Directive Principles of State Policy, which provides as follows. The exercise and enjoyment of rights and freedoms is inseparable from the performance of duties and obligations, and accordingly, it shall be the duty of every citizen to A, to promote the prestige and good name of Ghana and respect the symbols of the nation, to uphold and defend this Constitution and the law, to foster national unity and live in harmony with others. Go and use the new one. You know I use the new one. To respect the rights, freedoms, and legitimate interests of others, and generally to refrain from doing acts detrimental to the welfare of the persons, to work conscientiously in his lawfully chosen occupation, to cooperate with lawful agencies in the maintenance of law and order. I will adopt the words of the law Lord in the Mantse 3 case as my own and say in this regard, the respondent has failed dismally and deservedly needed to be punished for contempt. Amakani biye koni ona noni poteni jeje ke. Jeje ke noni kandi efe akamla ko ege komo. I will adopt the words of the law Lord in the Mantse 3 case as my own and say in this regard, the respondent, in this case, Nii Adote Otinto, has failed dismally and deservedly needed to be punished for contempt. No jaje ke efeli nibi nimla expert ola ake fe ake manche efeli na kan nibi efe ni nowo esani agble to eja ke eche ko to here atwa. On the need to punish for contemptuous acts perpetrated by the citizens, a leadership, Bamford Ado, Justice of the Supreme Court, in the Republic versus Nii Danso, said, this is the reason why the courts are giving power to commit for contempt. That is to punish any acts which tend to interfere with the proper administration of justice or which scandalizes the courts by eroding public confidence in them or by weakening and impairing their authority. The power to commit summarily for contempt is indeed an effective but very powerful tool which must be wielded only in very clear cases. It must be noted, however, that it is not to be used from a tenderness of feeling or to vindicate any particular judge. It is used to protect the whole administration of justice and to keep the blaze of glory round the courts for obvious reasons. The public must have confidence in the law and the courts, and any attempt by anyone calculated to erode such confidence must be viewed very seriously and must be punished swiftly to restore the integrity of the courts which administer the law. As I had already reiterated, we live in a society of rage, and there is the need to exercise the judicial whip, which, in the words of J.A. in Republic versus Pone Traditional Council and two others, ex parte Alaji Tetekwao and two others, 2008 Judicial Law Review, is entrusted to the custodian of justice of the justice delivery system to correct members of the public who by their actions or words deliberately seek to undermine administration of justice. This judicial whip will be exercised in the present action to remind all and sundry that nobody is above the Constitution, and that if the Constitution vests a body with an authority to adjudicate disputes between its citizens, the work of that body should not be undermined or be brought into disrepute by anybody, including chiefs. So, in other words of Ephraim Benjamin, Justice of the Supreme Court, in R.E. Efijuase Stool Affairs, number 2, the law, of course, is not a respecter of persons and would exact the requisite penalty whenever so merited. So, now, sentence. I have taken notice of the remorse shown by the applicant. Nii Adote Otinto eba jwe ake eglaise yemone yueshi Nii Danso eglaise nyeka yake naga yemo mi no ewe ake yemone yueshi numo babu keme keningbese egla na kan no fense jeje ke na kan no ehia womi ena na kan no efa mage enyake woche Nii Adote Otinto efe na kan ko efa maga aba punishile fe boni apunishile. So let's go on. I have taken notice of the remorse shown by the applicant and efforts he has made to remedy the effects of his action, but I have not seen any rendition of apology to the applicant and the retraction of his statements, which will add weight to his sense of remorse and water down the ramifications of his actions or words. Yes, in an video, she nagano ekpakofai she ekpakofai. No because fight pamo be me wo na chimo ni yo na kan yemo na glass can you fight pamo ye minku e ka chimo agbo ba wo na kan yemo na glass yes in na ke glass mo she fight pamo fitai so e fight pamo fitai nku e ba na lewa ni ebani nonima yuene the ramifications of his actions or words ebani ebashifio water down the ramifications. Consequently, this court will caution the respondent and he will sign a bond to be of good behavior for a period of 12 months. So, Nii Adote Otinto, if I sign bond for 12 months, Nii Adote Otinto ba sign bond, okay, it will be of good behavior. Okay, this will be in consonance with the words of Akabuafo Justice, as he then was in Republic versus Openyin Kwesipra and 5 others, ex parte Openyin Kwame Nyaku and Ano 2025 which states, without contempt a sword of Damocles, bullies in our society will run roughshod over the marginalized. Locuta curia, cosa finita. The court have spoken, and the matter is finished. Locuta curia cosa finita. The courts have spoken, and the matter is finished. So there you have it. In essence, Nii Adote Otinto was fined. I think there was no corona Sempe. There was a cost that was given him to pay. Enemy. Oh, maybe the other one. Okay, not this one. Okay. Right. So, like I said, in essence, Nii Adote Otinto was found guilty of contempt. He was found guilty of contempt, and I thought, okay, yes. So, na sign bond for 12 months to be of good behavior. So, no jinoni onane. So, yes. Contempt case Nii Danso file against Nii Adote Otinto. Judge find Nii Adote Otinto guilty. In essence, Ni ane a sign bond to be of good behavior for 12 months. Nakanji noni onane. So, ladies and gentlemen, there you have it. Like I said, what 2 hours and 47 minutes. Let's leave it here for today. Other one ever fit here. Now, stay of execution. Ni Nii Adote Otinto file. Minijinoni teno. I have it. And you win stay of execution. Allow away chafum. Let's do that next week. Let's show ne se ba jeke chon. Bona. That will take us another hour or so. You know, bana what 4-5 hours me. So nyani wakene hour be. I don't think I get any. There is a need for phone calls, right? It is what it is. You understand what I'm saying? Once again, if you are watching me, this is not because I have anything against anybody. I believe keji wate no ni wate no ni wafe no ni isani wafe no fe no ba ya no ojogban. You understand what I'm saying? One fe because one town ni gan chake ni anukwale page no ni banye e chake gan. You understand what I'm saying? Until ni waba boy wa ya anukwale yeli until ni wabanye waboy wa ye anukwale yeli if you ake waba tabi no. And that is why we do this. You understand what I'm saying? We'll continue to bring you everything. Konole insumoni mogoba wo bokotu. Ko blanta jibono ye gan ni kan mo kan febo awunto ni o mata bi ni gbla mi ha bo insumoni mogoba wo kotu no ba no mogo ne sa because akebo anukwale coffee na I'm telling you obaya more free aba obo mo easy. You understand? Because they go le mo ne ba kebo no go no ba fe le lenche court to ngbale no le lenche na gbale bo te ba fe de ba ile bo ona boni ni yo. So ladies and gentlemen, nyefenye yana walada waka wani femo eba. So like I said, in essence, this court will caution the respondent and it will sign a bond to be of good behavior for a period of 12 months. And so Nii Adote Otinto is signing like a bond there, I am sure, to be of good behavior, to be of good behavior for 12 months. Ho afi Nii Adote Otinto eba beshi din if magege you no go sande ne ko ele waba na no ko papa ona boni ni yo. So chamega nyame there is really nothing to say, right? So I'm not going to open the lines. Let's call it a day. Oyiwaladon ake obafita way. Shout outs to Mofe Moni Babie, Atokankpa, Shatta Drake, Numo John, Man Christy, Man Roberta, Man Awa, everybody. Numo John get signed to be a good schoolboy. I don't get a good apology as 3 parts. I'm sorry. It's my fault. What can I do to make it right? Most people forget. Thank you. Impa, this is absolutely right. No, you be anokwaleni ojogba adenche. Indeed, a good apology has 3 parts. I'm sorry. It's my fault. What can I do to make it right? That's true. And we want to well, it didn't say all of the above, anyways. But that's right. That's right. So the judge did the right thing by finding Otinto guilty, but he has to apologize to Nii Danso. I agree with you. Look, we are all brothers. You understand what I'm saying? Come on, ni la tenugweje asma nchekwe inni ke enin nyeme inni ke papa. You understand? Out of nowhere we are connected. Ma saneni bwen yue mo like oh mo go echa me where no le money sane no you oh nakan asma oh inye kunche. You understand? So God, we are all connected. And can you buy your way no quali on a boninchon? Ni wa fe wa yaka wa ba shishi wo yi. Because any shishimo clearly shishimo. You understand? Shishimo ne sana shishiyomoko. And of course, that is why I do this, so we can shine light on some of these things. You understand what I'm saying? So I would not get tired of reading these things. Sometimes it gets boring. I try to make it as exciting as I can. You understand what I'm saying? Me and Sumoni Kanebo. So I can read for 5 hours. They told me. But it gets boring. Sometimes I don't try to feel a little exciting. But because me tell my candidate keke, but me tell you mo fame one no kwale ni ya no ne kesan jin fame ona bonia fe ni wo bi ni baba I mean like look esa ni wo yon shin le boni wo cheme yon shin bia na it's not right, it's not good. You understand what I'm saying? It's not right and it's not good. Ona boni ni yo John, you read like a tuguba. Thank you. Yes, indeed, part to Nii Danso, indeed. So chemega jeme. We will start another week, and hopefully we'll see what the court holds for us next week. Thank you. Well, lawyer ke lawyer benli ake ili ake o kwa class ano ani male ni shwenge ke we ba no gaga oba munafio hawo before let me see nyam one second lawyer ke no matter no matter the noises made, the law is the law. Let me see. I go over na lawyer ni. Wabana lawyer ni eba munafi awolo. Let me see. Ili ake lawyer nkwa wakula. Benyele wo lawyer. Ke bale ne ke maji ansanjin. Nyele wo lawyer. Lawyer over ne alo ge ngene wachi awomi. Over ne kwamo fu no. Over asumoni o chip in a word or two. Benyele ke bale ne ke we rely on legal expert Alhaji Malik. Ili ake kwa wakula because a text here be any manashi. A text me. Anyways, let's call it a day. So and thank you guys so much for always supporting. Thank you so much, ma. Yes, I'm a quick. John, we must hear from our lawyer. Okay, Imbile Sani. Lawyer. Oh, okay. So again, Kenya, joining late. So next time. It's an issue ma promptly. So joining late. So nyani wafiani ne bona. Benyeli ake always say he's available. She mene joining was late. So next time eba nyeli ake always ke available no eba chonwo ni bi ke wo kandi wi mo atan. Man anyway, so once again Yana Walada, I don't know, should I say this or okay, all right. Oh, okay, let's see. Hello Aji, salam alaikum.
Alaikum salam.
Oyi wala don ye wa do mo to ba man be even though ba join wole later man be guys ani esana amenu yi. Yeah, niggas on the so fine. Our 2 cents. Our 2 cents. Danny walk back.
Yo, kenkle minga mo fe minga ebule minga meni nkobu.
That's right.
Efe mo fe mo yo ni kobu beka na shine. Minga mo fe mo. Ihe ya ke mo fe mo yo jugba. Efe mi ake shi ni no kan yo ke fi ogla mi o. If you in action, feel work more easier.
That's right.
Hey, honey, work feel more easier. Just that equally some legal technology say equally neighbor no shishi. Hey, especially equally. I think in general, no need here, no blame.
Right.
No go be say don't because at the end of the day, I get more content emule. No go be na abafi
right.
Content like mobu. Ibale na kan. Ibale na kan. Mukumba atayeku ni mukuba na judgment.
Right.
Ni iba rubbish. Effort anymore if ye.
That's right.
Cause muku efi ejemi. No muku le ba kono iba dumono ni lehu iba fiku. This should serve as an example.
Right.
To mo femo. Irrespective of your status.
Right.
Ino dumo. Position no here. Akeshi sani wabumla. Mla ke neke wabule. Ni wafeno ni isani ke na bakukra ibaha wo.
That's right.
Ikembuku ke wake yanu afine. Alo yani wafi tafla chebulu ani nku. Kuni ekeshika ba ajibuwe. No le akeshi. Ishoheko ni shikanye fi nuku.
That's right.
Ishoheko ni shika ke ohiwale ko koneshi nuli fe inye wabu. No, this should serve as an example.
That's right.
I also like the comportment of Nii Sempe. At least ni content ne bane. Eka ke iba media no ni ba femini. Iba wiku.
That's right.
Ye sure akeshi you abide by whatever decision ni kote make. No offense and wo ke fe ni kasimo.
Nakai.
Ni wohani bla obumla. Omo oye nuku ni bona. Ya kote.
That's right.
Kote afi structure say kemeshi. Amen. Ni uso appeal decision yene judge fu ameye tam yo je. Onupa ko wominga eke on kote ni jene corruption can be institution ko be ni corruption ko be jen. Man ko kra be jen lemi ni corruption be man.
That's right.
See aya structures. Ni obani ni okefe mini. Ukana ni tawo.
That's right.
High court ke jeje ekumepe kajen. Ke numra nyo say ni ya fe judgment which is not in your favor. Ya appeal judges amiyete.
That's right.
Na metaje. Wo kemo ke eshika. Ibanye ha me enyo eshika yemi. Ani ha me. Ko gbina ya appeal ko no Supreme Court. Je ko na kra judges abanye ha 5. The minimum, abanye ha 5.
Right.
Akwe case ni case mi chiye ona. Abanye ha 7 judges.
That's right.
No, on the weight of the case, ni aba benche ojugba.
That's right.
Akeshi have 5, alo have 7 judges. No, ke eshika ni 5 judges. Ni ke banye ni bribe.
I'm a fair
3 mi. Bele eshika fitio.
That's right.
Alo no mo eshika fitio.
Yeah.
Eko no ni he na apeli opole nche. No ko bibio ko ni ko eshika no fitio bele nche at the end of the day. Sena mo kukra popo ba no anai.
That's right.
See, come lad dubue. Banake yes.
That's right.
Be no fiti efe mla eba dumose. No me nga fi onima wo ne. Since no okay case abacha no in 2 weeks time me. might reserve any other contribution in regards to this case. Have to do with any or
that's right. Thank you so much. All right. Okay. Bye-bye. Okay. So there you have it with Alaji. Shout outs to you. Naomi sir. Oh no way Akubu. Mene money in Chunuchumo. Bagoda ni nabu. Oyebi ekejiji. No way Akubu. Bagoda ni nabu. Mene ni Chunuchumo abu. Bagoda ni nabu. Oh, basano ya se no akwe. Sano ya se no akwe. Simene Chunuchumo habo. Anyways, yes, Namisa of elite. Yeah, that's right. So next week, tumobeni nkebwe the substantive judgment ni nono edumoni ne kendo kone ba ni Nii Otinto. Now, Nii Otinto file a stay of execution against the judgment. Miniji no ni te no court ni miniji no ni judge ke next week wababa bie ni kendo eba habo ke kona any saneneya. And like I said, every single case ni ya no ye washikonjiano I will come bejani ni share wolueno shikeni ni share wolueno eko sanjini ya no wakukpajiano fe mama tabie ni makane fe and I will try my possible best. Ona tumobeni alaji yue. I'm not a lawyer, so be legal terminology say come bonde sani magblam yojugba nye magblam yojugba law je blofoni you more than church mo Latin me mlenche blufu kwami ahin me denche blufu kwami ahin ko Latin. So it takes a special skill, you understand? That is why I can lawyer I pure scapi na school na chon law. Don't disrespect the profession. So I will try my very best. Oh, okay. All right, it's California time owner. So Paco, okay. So like I said, owner bonini yo. You need the experts to sometimes explain it to you. No matter how you a bluff and there is a special skill. Ni I'm a pure scapi na make casio. So always say about trying Obana Laji and Oni eba chon what you do. Once again, what for 3 hours and 3 minutes. Once again, nyefenya you wala don ukpreja jonye. Obakpe ebi eko. Bye bye.